Testing, testing. Dave, can you hear us?
I can hear you. Can you hear me?
Yep. All right,
Alrighty,
thanks.
thank you.
Hey, Dave,
Yep.
which item are you on?
Say again.
Which item are you on?
This is Dave Hoppick. I am on.
Okay, good morning. Welcome to the Public Service Commission's administrative meeting for November 26, 2024. First item is to approve the minutes of our meeting of November 2024. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Morning, Mr. Chair. There's 6 items on today's consent agenda. Item number 1 is a petition from Aberdeen Solar LLC for an extension of an operational deadline for community solar. Item number 2 is a notice of bond cancellation for America Approved Commercial LLC. Items 3 through 6 consist of revised tariff pages from Baltimore Gas and Electric Company, Potomac Electric Power Company, Delmarva Power and Light Company, and the Potomac Edison Company.
Okay, regarding item 1, I move we grant the company a waiver for the operational deadline for the Aberdeen Solar Project until January 18, 2027. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 2, I move that we cancel the company's licenses to supply electric and natural gas services. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 3, I move we accept the tariff provisions for filing with an effective date of December 1, 2024 through February 28, 2025. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 4, I move we accept the tariff provisions for filing with an effective date of December 1, 2024 for Type 2 customers and June 1, 2025 for residential and type 1 customers. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 5, I move we accept the tariff revisions for filing with an effective date of December 1, 2024 for type 2 customers and June 1, 2025 for residential and type 1 customers. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye. And regarding item 6, I move we accept the tariff filings for filing with an effective date of December 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And item number 7 on the administrative agenda consists of tariff revisions from Baltimore Gas and Electric Company.
Good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff. On October 25th, 2024, Baltimore Gas and Electric filed Supplement 721 to its tariff in order to comply with Order Number 91339, issued on October 1st, 2024, in case number 9478. The proposed tariff revisions allow separately metered EV charging at multi-unit dwelling locations to qualify for Schedule G and GS rates and charges. These revisions comply with the Commission's directives in Order 91339 to allow multi-unit dwelling customers to have the choice of a time of use rate and a non-time of use rate for EV charging, which also excludes a demand charge. Schedule G is BGE's non-time of use rate, and Schedule GS is BGE's time of use rate. Staff recommends that the Commission accept BGE's proposed tariff for filing with effective date of December 1st, 2024. And then in regard to Mr. Burkowski's comments that were filed, staff believes this is only an issue for Baltimore Gas and Electric. If you may remember, all the other utilities proposed multi-unit dwelling rates. They use their residential rates for multi-unit dwelling customers, whereas BG's using commercial rates. Staff really doesn't have an opinion at this time. We'd have to ask for the comptroller's ruling on this. But I just wanted to clarify that this is only an issue for Baltimore Gas and Electric in staff's opinion. Thank you, and I'm available for questions.
Okay, any questions for staff? But let me ask one. So does that impede our ability to approve this today?
I don't believe so. I believe BG can clarify, but I believe at the last administrative meeting they did say I think there would be some billing changes that would need just say, for example, the controller said not to charge sales and use tax to these customers. I do believe they said there could be take some time to make those billing adjustments, but it shouldn't impact this.
Yeah. Okay.
Good morning, Commissioners. Isaac Lindenbaum on behalf of Office of People's Counsel. OPC did not file a letter for this item, and we do not object to BGE's filing. However, we also agree with staff in that we believe the Commission should seek a legal determination addressing whether the sales and use tax applies to multi-unit dwellings receiving electric service on residential rates. At the last administrative meeting hearing on September 4th, there was also some confusion on this issue. And then considering also Robert Burkowski's comments on this matter, we do believe the Commission should seek a legal determination on this issue. And we're happy to follow up with the Commission or staff after today's meeting to help get clarity on this issue. And I'm available for any questions.
Any questions for OPC? Okay.
Morning, Chair Hoover, Commissioners, Daniel Herson for Baltimore Gas and Electric. Just here to answer any questions. On Mr. Borkowski's comments, we don't have any objection to staff or OPC's recommendation. I don't think this is an issue that BGE could approve. If a customer wants to seek an exemption from the comptroller's office, they can do that, but I think that has to be a decision that the comptroller makes. I'm not sure the Commission would have the authority to even grant that as well. We just got those comments yesterday. I haven't had a chance to run them by any tax experts at the company, for example.
So I guess one question, and I don't know if this is either for staff or BG&E or OPC. I mean, does the comptroller's office issue tax advice? I mean, I'm used to the IRS, issuing those tax guidance statements, but I guess I'm not familiar with the comptroller actually doing it.
Well, I believe it's come from the Attorney General's office previously. I believe that's who we asked years ago. But
Yeah, I don't know if I've seen any guidance letters. I know we've had correspondence with comptroller's office personnel before about individual issues, but I'm not sure of the answer to your question, Your Honor.
Okay. Any questions for BG&E? All right. Seeing none. All right. So let's. I move we accept the proposed tariff for filing with an effective date of December 1, 2024, and I guess request staff that we reach out to the comptroller's office and find out if there is an issue and whether they have an opinion on it.
Sure.
Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 8 consists of revised tariff pages from Southern Maryland Electric Cooperative, Inc.
Good morning, Chair and Commissioners. David Hoppock on behalf of staff. SMECO made its compliance filing in case number 9738 on November 1st, 2024, with proposed rates effective December 1, 2024. The Public Utilities Law Judge proposed order in case number 9738 states that it will become a final order on November 27, 2024. SMECO's compliance filing provides SMECO's proposed distribution base rates, tariff changes, and updated bill stabilization or BSA factors. Staff has reviewed the proposed tariff language changes to charges, and new rate class, Schedule CP Crane Point, and confirms these changes are consistent with the proposed order. Regarding distribution base rates, SMECO has implemented the allocation, customer charges, and weather normalized kilowatt hour sales for BSA rider classes in the proposed order. Schedules GSM, GSL, and LP have both distribution demand and volumetric charges. SMECO has proposed to set distribution demand and volumetric charges based on SMECO's direct testimony rate design in the instant case. Staff recommends setting distribution demand and volumetric charges for schedules GSM, GSL, and LP such that relative revenue recovery between distribution demand and volumetric charges is maintained as staff proposed in testimony in case 9738. Staff believes this method is consistent with the proposed order statement that cost recovery through volumetric charges promotes energy conservation and maintains greater customer control over bills. Staff recommends that the Commission accept the filing as revised by staff with an effective date December 1, 2024, require SMECO to file clean copies of its tariff, and require SMECO to file revised BSA factors for schedules GSM and GSL. Thank you. I'm available for questions.
Okay. Anything else from Mr. Dean, or is that covered it?
That covered it, Your Honor.
Okay. Any questions for staff? Okay.
Good morning, Chair Hoover, members of the Commission. Damon Krieger on behalf of Southern Maryland Electric Cooperative, and happy holidays. So the only misalignment here is as Mr. Hoppock indicated, between the allocation of revenue among certain of our commercial classes. We think that Judge Burke was silent on this issue in her proposed order. We think our proposal and staff's proposal are both reasonable, and therefore we do not object to staff's allocation as between the demand and energy charges for the indicated classes, general services medium, general services large, and our large power classes. So we are comfortable with either allocation and believe both are reasonable. Happy to entertain any questions.
Any questions for SMECO? All right. Seeing none, I move we accept the tariff for filing as revised by staff and its comments dated November 20, 2024, with an effective date of December 1, 2024. Direct the company to file clean copies of its tariff, and direct the company to file revised BSA factors for schedules GSM and GSL. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Thank you.
Item number 9 on the administrative agenda consists of revised tariff pages from Association of Maryland Pilots.
Good morning, Mr. Chair and Commissioners. Oh, thank you. Thank you. Good morning, Mr. Chair and Commissioners. Lucy Shea on behalf of staff. On October 11th, 2024, the Association of Maryland Pilots filed revised tariff sheets to become effective January 1, 2025. These charges would apply to all vessels piloted in the Chesapeake Bay and its tributaries. Maryland pilotage rates and charges are established by the Maryland Public Service Commission pursuant to Section 4303 of the Public Utilities Article of the Annotated Code of Maryland. Services offered by the Maryland Association of Bay Pilots consists of two regulated rate structures. Number one, the bay rates and charges, and number two, the docking rates and charges. By order number 77555, effective February 19, 2002, the Commission accepted a settlement agreement in case number 8904 to increase, set, and establish future adjustments to the rates of the Association for pilotage services within Maryland waters. The settlement agreement provided for an annual Consumer Price Index inflation rate adjustment to the association's rates that would become effective January 1st of each year until the settlement agreement is terminated by one of the parties through written notice. The settlement agreement specified that the CPI inflation rate adjustment would be calculated using the most recent 5-year preceding moving average change in the rate of general price inflation as measured by an Urban Consumer Price Index issued by the United States Department of Labor. Staff reviewed the filing and verified that the proposed tariff rates properly reflect the CPI 5-year moving average increase of 4.22%. Staff recommends that the Commission accept the proposed tariff for filing effective January 1st, 2025. And I'm available. Thank you, and I'm available for questions.
Any questions? All right.
Morning, Chair Hoover, Commissioners. James McGee on behalf of the Association of Maryland Pilots. With me today is Captain Eric Nielsen, the President of the Association, and we're happy to answer any questions that you may have.
So, any questions? Oh, Commissioner Richard.
Since Captain Nielsen's here, just for my information, are other ports, do they set rates in a similar fashion, or is it? I'm just curious if other public utility commissions also do this for other ports.
There are actually 3 associations in the country where the Public Service Commission sets the rates, and it's the Washington State, Virginia, and here in Maryland. Other pilot associations' rates are set by their General Assembly or the Pilot Commission itself that regulates everything else. So we were among the very first to hit upon this, and since then, virtually every other group is trying to copy it, either by setting the rates to mimic CPI increases if it's a General Assembly or Pilot Commission, or just through purely, like in Oregon, it is based on the CPI changes. So it has worked well here. Our industry's been very satisfied, and so it's been copied throughout the country.
Okay, good. So this is considered a best practice than the way we're doing it.
Amazingly,
Okay.
yeah.
All right, terrific. Great. Well, thank you. Thank you, Mr. Chair.
Anybody else? So, let me ask one question. I take it everything's back to normal at the port?
Well, as of November, it is. It took a long time
Right.
to get back. The port was open, the harbor was open in June, and some traffic returned immediately, but a lot did not, especially container traffic, and particularly from Asia. So it's really taken until this month to get back to where we were pre-crisis.
Okay. All right, with that, I move we accept the tariff revisions for filing with an effective date of January 1, 2025. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Item number 10 is an extension request from Potomac Electric Power Company.
Good morning. Good morning, Chair and Commissioners. DeAndre Wilson on behalf of staff. On October 11th, 2024, PEPCO filed a request to revise the operational deadline for its Fairmont Heights microgrid pilot project due to unexpected delays in obtaining the necessary permits to complete the project. The company originally requested an operational deadline extension from December 31st, 2024 to March 31st of 2025, but after its filing, PEPCO has now requested an extension to May 31st of 2025 for good cause. PEPCO's Fairmont Heights microgrid project is a utility-owned and operated microgrid comprised of 120 kilowatts battery energy storage connected to 6 single-family net zero homes, each equipped with their own 17.9 kilowatt solar PV system, for a total capacity of 227.4 kilowatts. The primary application for the energy storage system will be for islanding, peak shaving, and load management, local resilience, and local grid flexibility, and will serve the loads of the 6 single-family homes and operate as part of the Maryland Community Solar Pilot Program, where the homeowners will be offered a subscription to participate in the program at no upfront cost or monthly subscription fees. The nature of PEPCO's request for an extension of the project operational start date is due to an unexpected delay in obtaining a building permit from the Prince George's County Department of Permitting, Inspections, and Enforcement for the construction of the central housing location for the energy storage system components, and the complicated nature of the land and asset ownership associated with the project. PEPCO has requested the need for 2 additional months because the Department of Prince George's County Permitting Enforcement had additional questions for PEPCO's vendor regarding the unique property versus asset ownership associated with the project and the need to revise its application in order to address the battery that will be located inside. Once the revised permit is issued, construction of the battery storage building can begin. The company has not expressed any increased project costs due to the project's delay and does not have any updated costs to report. Staff still supports the company's request for staff supports the project and the company's request for an extension of the Fairmont Heights project as being in the public's interest because it promotes important principles that align with the Climate Solutions Now Act, as it gives priority to vulnerable communities, provides the flexibility to leverage microgrid capabilities to manage load variability, provides grid support to other parts of the grid, and reduces energy consumption to address load variability. Pursuant to the statute, staff recommends the Commission approve PEPCO's request to extend the operational date for its Fairmont Heights project to May 31st, 2025 for good cause, subject to the conditions set by the Commission Order Number 90453 and Commission Order Number 9088. Staff is available for any questions.
Any questions? Seeing none?
Morning, Chair Hoover, Commissioners. Mark Shebus for Office of People's Counsel. OPC is in agreement with staff's recommendation here. We support the extension with the condition that the company continue to make the reporting that the Commission ordered in its previous order granting an extension. Mr. Seegers, before this hearing, pointed out there's an error in OPC's letter. We express agreement with an extension to March 31st, 2025, which was the original request by the company. Subsequently, Mr. Seegers reached out to staff and OPC and said, like it to be the end of May. So OPC agrees with that. We have some other comments concerning the implications of this delay for the pilot as a whole, but I will save those for the Delmarva application, which is coming after this one, and I'm available for any questions.
Commissioner Sussman.
So,
So I'm trying to understand what it is you're asking in terms of the HEPCO proposal. There had been some conversation in your filing about a second round of interim lessons learned reports. Are you still asking for those, or are those in connection with Delmarva?
I believe that was, yeah, OPC's request. It's a request more proper for case number 9715, the Maryland Energy Storage Initiative Working Group, and we intend to bring it up there, but it seemed relevant to bring it up here because, and this goes to the issue of the implications of the pilot, so I can get into that now. You know, the fact that these projects will be delayed as far as they are means that there's going to be a relatively brief period of operation before the commission has to conduct its final review of the pilot in the summer of 2026. And that, you know, raises question about like how much value these projects have for the pilot and larger questions about the value of the pilot itself. When this pilot program was established by the General Assembly in 2019, I think that the concept was that the state would experiment with these different models of ownership and operation, and the learnings from the pilot would inform further energy storage policymaking in the state. Well, in 2023, the state, you know, decided to enact Public Utilities Article 7.216.1, which, as the Commission knows, established these very aggressive energy storage targets, 3 gigawatts by 2033, and directed the Commission to establish a program with a start date of July 1st, 2025. The Commission, in its comments to the legislature, actually said, well, perhaps this should be July 1st, 2026, so that it would start when the pilot ended. But the General Assembly decided to start it before the pilot ended. So this raises the question of how do we ensure that the learnings from this pilot program really matter for energy storage policymaking in Maryland? How do we make sure they're taken into account in case number 9715 in the Maryland Energy Storage Initiative Working Group? Last year, when the Commission established that working group, and MESI, I think is what we're calling it, the Commission directed all of the utilities with pilot projects to file these preliminary lessons learned report in case number 9715. I think there was some discussion of those, but I think it's probably ripe now for another round of sort of inquiry into, you know, in that working group of what's going on in the pilot, how can we best take advantage of the learnings as we have them so far from the pilot so that they're actually informing MESI. Our concern is that given the timelines of these two different proposals, that if we don't have some interim steps, this pilot will turn out to be just a paper exercise because all the real work is going to be done in case number 9715. And while the results of this pilot could inform things along the way, we may lose opportunities to really take advantage of the pilot learnings for the MESI program.
Okay, so that I understand, your concern is that the work being done in 9715 will have already been done before you even get the results from the pilot.
Correct.
Okay, so just so that we don't have, you know, multiple sort of reports coming in a number of different proceedings, is there a sort of a way of ensuring that the results from the pilot that we're talking about now, where it's being sort of extended so that the pilot itself, once the storage goes into place, the pilot will end then when for this one?
I think the Commission is directed to make its final review of the pilot projects by July 1st, 2026, although the statute does authorize the Commission to extend that date. And there's an argument for doing that for these projects to enable a longer body of operational data to review. The problem is the more you extend it, perhaps the less relevant the results become.
Right. So this storage facility won't be operational until May of 2025. So realistically, how much data is going to come from that pilot that's going to find its way into 9715?
Well, A year less if the commission sticks with its current, the current statutory deadline of having a final review of the projects by July 1st, 2026.
Right, and then there's the PUA that the utilities are required to file in 2025, but they're not going to have any information on this particular pilot because it's just going to become operational. Okay, so I guess so that we're not sort of requiring multiple reviews in multiple different proceedings. Is there a way, maybe you can go back and speak with Pepco, is there a way that we can get this information into some filings so that there's a legitimate lessons learned from the pilot? Because I agree with you, it doesn't make sense if you're running a pilot that's beginning in May of 2025 where filings are already being submitted at that same time without the benefit of this pilot.
Yeah, Commissioner Stutchman, I do think the commission could, like for these particular projects, order additional reporting, in addition to what's required in the statute. I think you're right that the 2025 reporting date directed in the statute will basically mean that no data gets reported for this project.
Yeah, I'm concerned
But
about that
the
too.
commission could say, well, we want additional reporting in the spring of 2026, so that at least then we have, 8 months or so of data that the commission can review in 2026.
Well, maybe we can hear from Mr. Seegers about whether, I continue to be concerned about multiple filings in multiple, because then it comes to us and our staff and we're a little overwhelmed. So it, to the extent that we can streamline this and have it, have useful data be submitted somewhere in some proceeding, that is what I'd be interested in.
Okay, so actually,
But
before
I'm
you-
sorry, I didn't mean to
No, I just
hijack
wanted to
this.
check to make sure. So Commissioner Barbe has a question for OPC. So-
Yeah, I thank you, Mr. Chairman, and I share your disappointment at the fact that Maryland appears to be this state where no clean energy project can happen quickly. But in this instance, really, this is primarily the fault of local government decisions. Isn't that where the nexus of the problem rests in this and in many other instances?
That may well be, Commissioner Barbe, and to be clear, we're not opposing these extensions. We haven't delved too deeply into the reasons for them, but we think the company has shown justification for them. Our concern is just that whatever the justification, the effect of their starting as late as they're starting will limit the amount of operational data for the commission to review.
Well, I agree with that. I just think that, and I don't disagree with much of what you've said, actually any of what you've said. It's just that the impression would be left that somehow we are complicit in this delay because of the rulings that, and it's really not. It's we have tried to move as quickly as we can as a commission. It's forces outside of our control that really have bogged down the process of trying to do solar projects, do battery projects. It's really we are more reactive to forces outside of our control than we are the genesis of those delays. Would you agree with that?
I agree, Commissioner. And to be clear, I was in no way suggesting that the commission or even the companies are dragging their
Oh, I didn't want to imply any animus on your part. I just wanted to make sure that it was entered into the record as to what the real bottlenecks are in the state.
And out in COVID, right?
Yeah, but it's been years since that, and these slowdowns have occurred since the third vaccination that I've received. So I don't think we can blame COVID entirely for all of this. Thank you, Mr. Chairman.
Any questions? Okay, so Pepco.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers appearing for Pepco. We appreciate both staff and OPC's analysis and as well as their recommendations. Regarding OPC's recommendations in their letter, we have no objection. The only thing I would note is that in terms of including a additional report in 9715, I can only speak for the PHI utilities. We don't object to that, but I can't speak for BGE or Potomac Edison. It sounds like we may be going a different direction, so the company would of course be willing to provide whatever reporting the commission feels necessary, because we do understand the time conflict about having sufficient data from this project in order to make the commission's report worthwhile. And I would like essentially to provide an overview and some background on why we're asking for an additional 2 months. In terms of the overall project itself, the houses themselves are built. The distribution system for the houses are built. What we are talking about here is what's called the Central Energy Park, which is going to consist of the building that is going to house the battery and the microgrid components. When we first submitted our extension request, our vendor, well, let me back up. Really what the challenge involves here is the unique property ownership that's associated with this project. When Pepco, when we do a project in Prince George's County ordinarily, we own the property. So what we normally have to do is just get the building permit, and that covers everything inside whatever structure we are going to build. In this particular case, we do not own the property. We have an easement there. The property is owned by the Housing Initiative Partnership. So that's what is causing essentially the permitting issues that we're running into. When we first submitted our extension request, there was a building permit that was issued for the structure itself. And then there was a question about whether or not the battery and the microgrid inside were going to need electrical permits from DPI. As I mentioned before, if Pepco owns the property and we're doing it, we don't need to get an electrical permit. All we have to do, that is built into the building permit. In this particular case, because we don't own the property, the building permit that was originally issued only covered the building itself. And there was a question about whether or not an electrical permit would be needed for the microgrid and the battery for fire and safety purposes. So that is what led to our initial request. It was recently resolved. We work with DPI along with our vendor, and it was recently resolved that an electrical permit would not be needed just because we do have an easement, which is a property right there. However, the original building permit that was issued would have to be revised, and so in order to cover the battery and the microgrid inside. What I can report is, so what DPI, what they informed us is they said, here's the additional information that we need. I can report that information was actually submitted to DPI today. And DPI they have informed us that they will expedite the review of our revised building permit. Once we have our building permit, then we can begin construction on the Central Energy Park, like I said. And once the construction begins, it will take approximately 3 months. So that is hopefully answers some of the questions I'm sure you have in terms of why we're asking for 2 additional months.
So, Commissioner Barbe.
So you've asked for 2 additional months, and I think that's a reasonable ask. But if there's an opportunity for you to complete this project sooner, you'll do that.
Absolutely, yes, Your Honor.
So, okay. So I'd just be curious to know how quickly DPI responds, if you can let us know in the future.
They have assured us that they're going to expedite it, and it's our hope that we will have the building permit next month.
Okay, that would be excellent. Thank you.
Commissioner Sussman.
Okay, so I guess the question then is, I would like to see lessons learned. There's no question this is an important program, and we'd like to know what the results of those are. It could be in this proceeding, it could be in 9715. What makes the most sense? And maybe I can ask staff. Mr. Dean, do you have an opinion on?
Well, it could be in both cases. I'll say that. The 9715 won't necessarily have specific lessons learned, for a while, since they're still in the process of developing it.
Well, yeah, maybe it makes more sense in this proceeding because it is this proceeding that we're dealing with. Does that, and it doesn't sound like from the perspective of PHI, this is a heavy lift to include lessons learned?
No, Your Honor.
Okay.
We can-
All right.
Any other questions? So, I guess the one question I have, if we ask for this additional report, when is the optimal time that we'd actually would get something that would be useful?
If the project goes into effect, if it becomes operational by the end of May 2025, would a year's worth of data, is that what the commission has in mind?
Mr. Shebus, does that make sense to you?
Yeah, I think the challenge is that currently the statute says the commission has to conduct its review of all the pilot projects by July 1st, 2026. So my thought would be if the company, they start operation, say June 1st, 2025, maybe they make a lesson learned filing at the end of March, or April, which would be, hopefully enough time for the commission to sort of process that information in time for its review.
Do you have any opinion about that?
No objection to that, Your Honor.
Okay, so let's try this. I move that we approve the company's request to extend the operational date for its Fairmont Heights project to May 31st, 2025 pursuant to Public Utilities Article 7-216H6II for good cause and subject to the conditions set in the Commission's Order Number 90453 and Commission Order 91088, and require the company to file a lessons learned report in case number 9619 by April 30, 2026. Commissioner Suchma.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
And item number 11 is another request for an extension from Delmarva Power and Light Company.
Sure, go ahead.
Good morning again, Commissioners and Chair DeAndre Wilson on behalf of staff. On April 11th, 2024, Delmarva filed a request with the Commission to revise the operational deadline for its Ocean City Battery Energy Storage System project due to the delay of the delivery of the energy storage equipment. The company is requesting an operational deadline extension from December 31st, 2024 to April 30th, 2025. Delmarva's Ocean City project is a front-of-the-meter, utility-owned and operated 1 megawatt battery energy storage system with 3 megawatt hours of stored energy. Although the project does not defer a distribution upgrade, the project will provide peak shaving during periods of congestion and during emergency grid conditions, which will reduce thermal stress on Delmarva's system. The project will also provide power to the local library in order to improve resiliency during outages and reduce outage times, which is estimated to benefit more than 11,000 customers in the affected area. Delmarva's filing request is the company's third for its Ocean City project due to longer than normal lead times and equipment delivery delays. The company is now expected to receive the remaining energy storage system equipment on January 15th of 2025, which includes the battery enclosure and inverter enclosure. As of the company's filing, Delmarva was awaiting permitting approval for the project, and once received, will complete the project by constructing the foundation, installing and assembling the electric equipment, conducting equipment testing, and commissioning the project in order to meet the April 30th, 2025 operational deadline. Delmarva has reported that the company has not received any reports of concern from the community as it relates to the project, and there will be no increase to the project cost due to the project's delay, and therefore, there will be no change to the benefit cost ratio. Staff still finds Delmarva's Ocean City Energy Storage Pilot Project as a viable project in the public's interest, as it provides peak load shaving, improved reliability, and improved resilience during emergency conditions to Ocean City residents. Pursuant to the statute, staff recommends that the Commission approve Delmarva's request to extend the operational date for its Ocean City project to April 30th, 2025, for good cause and subject to the conditions set by way of Commission Order Number 90453 and Commission Order 91088. Staff is available for any questions.
Any questions? Seeing none.
Morning again, Chair Hoover, Commissioners. Mark Shebus for Office of People's Counsel. We have essentially the same comment for this request as for the PEPCO request. We agree with staff that it's reasonable for the Commission to grant the request with the conditions established in the Commission's previous orders, granting the previous requests. And we think it's reasonable to establish a requirement for a post-operation lessons learned for this project as well. And I believe the same date would be reasonable. It would provide a little bit more time for this project, given the slightly earlier projected operational date. And I'm available for questions.
Seeing none.
Good morning once again, Commissioners and Mr. Chairman. Matthew Seegers, this time appearing for Delmarva Power. We appreciate staff and OPC's comments, have no objection to their recommendations. Again, just to provide some additional context about our Ocean City project, Delmarva Power has all the materials that we need in order to put this project into service, with the exception of the battery and the inverter enclosures. Which essentially are the buildings they're going to be housed in. The enclosures themselves are actually constructed. What we need are two additional components, which is the DC disconnect and the automatic transfer switch. We anticipate that we are going to get delivery of those by next month, and those are going to be added into the enclosures, and then we're going to get delivery of the completed enclosures by mid-January, as staff indicated. And also, just to provide an update in terms of construction of the project, our vendor has completed the grading work to prepare the site for excavation and has begun installing the electrical grounding grid, and our groundbreaking for this project is scheduled for December the 9th. With that, I am available if you have any questions. I do have my project experts as well.
Okay, so just a couple questions from me. So the permitting situation is all clear. There's nothing left on that, right?
Yes. There's no concerns there, Your Honor. Essentially, what we are doing is we are responding to some questions from the fire marshal, just about some points in what's called our hazard mitigation plan. What those are is concerning signage in the enclosures regarding the location of the battery, as well as the duration of the alarm that's going to be installed. We are in the process of responding to those, and we anticipate that we're going to get the permit next week.
Okay. And if we require a lessons learned report by April 30, 2026, that's...
No objection, Your Honor.
Okay. Alrighty, with that, I move we approve the company's request to extend the operational date for its Ocean City project to April 30, 2025, pursuant to Public Utilities Article 7-216H6II for good cause, and subject to the conditions set in the Commission Orders Number 90453 and Commission Order 91088, and require the company to file a lessons learned report in case number 9619 by April 30, 2026. Commissioner Sussman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Thank you.
What's that? Yeah. Yeah.
All right. Item number 12 is a request for a hearing from Coalition for Community Solar Access.
All right, so why don't we, all the interested folks just come to the front so we won't have people dashing up to the podiums. See how much
How
room
much
we got.
interest there is?
Yeah. Well, actually, I mean, there's room, so however, well, let me
Your slide deck.
make room for at least OPC.
Chair Hoover?
Yeah.
We're going to have a panel of about 5 people. I think some of us could go to the podium, or we could all sit at the table, but we may have to shuffle around a bit.
Okay,
Just a
all right.
heads up.
No, that's fine.
Okay.
I will tee us up.
Sure.
Good morning, Mr. Chair and Commissioners. I'm Philip Vander Hayden from your technical staff and the work group leader for the net metering working group. On behalf of the working group, I'd like to thank you for taking the opportunity for us to bring this policy petition to you. It has been something that we reached an impasse on the working group after going through it multiple times, and I think the Commission has provided us with advice in the past to just bring the matters to us. So that's what we're doing here today. This is specific to the items that were in the petition. I think on page 6 of that petition, there's about 6 questions or so that we're asking you to provide us some guidance on. They all revolve around the issue of consolidated billing, which is the set of working group, the regulations the working group is working on now. This doesn't have anything to do with the regulations you adopted back in the summer, because those are on their way to Annapolis. So this is specific to the means by which a consolidated bill will be provided by the utility, which will include charges from the subscriber organization along with the customer's electricity charges. And the matter you have in front of you is specific to a particular set of words in the enabling legislation that talks about net crediting and purchase of receivables as the means to implement the consolidated billing. Staff has provided our comments and our recommendation on which of these methods that we believe is both most effective and the reasons behind that. So I won't go back over that here. I'm just going to sort of tee this up for you. I believe there are probably about 10 sets of comments in the record, and I think you've got representation here from everyone that will sort of advocate for their different positions. I would say that one of the things that's important to staff as the work group facilitator is we need some guidance. We don't have a set of regulations for you to rule on at this point, but we are working on those, and we need some guidance from the Commission from a policy standpoint as to which of these two approaches both meets the needs of the community solar program and then other regulatory principles like cost causation, that sort of thing. So we're looking for something to come back from the Commission in the form of guidance. It may be helpful to give us an order that sort of lays all it down, and I think we've tried to give you some specific questions that we're looking for answers from. That may be helpful if the Commission prefers to just tell us, from the record here. That may require some interpretation from us in the working group, but hopefully we can flesh out all these matters and answer all your questions to the point where we get some clear guidance. The work group will then, get back to this issue and continue to draft regulations. We will need to get those to you early in the summer, or in the midsummer of next year in 25, because we have to have this consolidated billing element into the community solar program by the beginning of 26. So with that, I think probably the various parties want to advocate to you, and it looks like we've got a presentation. So that's all I have, unless you have questions on the staff position and any of our comments.
Okay.
So,
Chair Sussman.
good morning. So before we go into the specifics of each of the different parties, can someone just walk us through so that we are all clear on how NC1 and NC2 would work? I think that would just really help all of us, help me. I mean, I sort of went through, I read it again. I just want to make sure I understand it because it's a little complicated. So is there somebody who can?
I think Yeah, I think the folks at CCSA have spent considerable amount of words putting that together.
That would be
So I think we'll
great.
let them
If you
take
could
a
just
crack.
go, we take NC1 first, or we could take them both at the same time, and you can sort of talk about what happens at the different stages. I mean, it would help me.
Sure. I'm going to run through all three options at the beginning of my statement. So-
Okay, in detail, so that we're clear.
Yes.
And I take it, I mean, you do have a preference amongst the three, but I understand this discussion is going to just be just the facts, so to speak.
Well, initially it's going to be just the facts.
Yeah, and that's
Just
what I'm understanding. So-
Exactly how it will work, and then we'll get into advocacy for what we think is the right
Okay.
choice.
Fair enough. Sounds good.
Your Honor, I will try to keep them honest if they say something.
Please do. My, good to begin?
Go ahead, sure.
Thank you, Chair Hoover, Commissioners. David Beaglemans on behalf of the Coalition for Community Solar Access. Echoing Mr. Vanderheyden, we really appreciate this opportunity to speak with you today. We know the Commission's very busy. It's a busy week. This is a very important matter for the industry. It's not hyperbole to say that the success of the permanent program hinges on this decision, which is why we're here today discussing this. I'm going to begin by introducing our panel. Then I'll provide an overview of the three options on the table, and then I'll talk about a matter of statutory interpretation that we think is dispositive on the NC2 option. With respect to our panel, on my left here I have Mr. Charlie Kogashal, the Mid-Atlantic Director for CCSA. We also have Georgina Ariola, Vice President of Policy for Perch Energy, in the audience behind us. Alex Passanen, Senior Policy Coordinator for Solstice. Chris Callaher, Senior Vice President and General Counsel for Ampion. Eric Wallace from the law firm Green Herlocker, also counsel for Ampion. I'll note that Ampion, Solstice, and Perch are all subscription coordinators active in the Maryland program and across the country, so they bring a wealth of experience. And then finally, we have Scott Elias, a Vice President of Policy and Market Development for Clean Capital, bringing a project financing and development perspective to the discussion. So beginning with the overview of the three options as presented by staff are NC1, NC2, and POR. Under the NC1 model, the electric company applies community solar credits to the customer's bill, and then automatically within the bill retains a portion of that credit as a subscription payment that will then be sent to the subscriber organization. Importantly, although the full credit is applied to the customer's bill, it is first used to effectively pay off, or in other words, clear the subscription charge that is owed to the subscriber organization. In turn, there is no need for the electric company to collect a subscription payment from the customer, and the remaining net credit is used to lower the amount owed to the electric company by the customer for electricity services. So effectively, you put the credit on the bill, then you shave off a portion of it and then send it to the project, and then the remaining balance is kept on the bill as a net credit. The subscriber organization, importantly, is paid by the electric company after the electric company renders monthly bills for electric service to all subscribers to the project. So only after that happens on the customer bill, a portion of the value is then transferred to the subscriber organization. And then also of note, to ensure clarity for customers, the NC1 model would also display the subscription rate and the resulting subscription charge used to calculate the net bill credit on customers' monthly bills, so they would have full visibility into how the calculations are working, although the net credit would be the only sort of change from a monetary perspective on the customer's monthly bill. So that's the NC1 model. The NC2 model, while it's referred to as a form of net crediting, it's really our position that it's not net crediting as originally envisioned. Under the NC2 model, the electric company applies the community solar credits to the customer's bill and then first uses those credits to pay off the electricity charges. In turn, the electric company then charges the customer for any remaining electricity charges in addition to the subscription payment. So the actual subscription payment is included as a fee on the customer's bill. The customer then pays any outstanding balance associated with electricity charges and the subscription payment. And at this point, once payment is received, the electric company transfers a portion of the money received from the customer to the subscriber organization, or in other words, the project. If the full subscription payment is not paid in full by the customer, The subscriber organization will need to track down the outstanding balance directly from the customer. So from a project standpoint in the relationship with the customer, that would be the primary relationship, basically tracking down the customer in cases of non-payment to the utility. And then finally, we have the PO.
Can I
yes.
just stop you for a second? I hate to do this, but because I'm really still trying to understand it.
Okay.
So in terms of the credit, the NC, it sounds like NC1 would apply. The subscriber organization would get the benefit of the net metering piece of it. With the subscriber organization would get that, as opposed to NC2, where it would apply first to the utility, to the demand charge. Is that am I understanding that?
Not exactly.
Okay, that's why.
I think, Your Honor, we will get into detail on sort of the differences between the two throughout our comments. So I don't want to kick the can down the road. Maybe we could wait a bit and
Well, actually, I mean, because at this point right now, I sit confused.
Okay.
So it would help me a lot if you would pick up that can and
Okay.
and try to explain how this is working.
Sure. It is going to get reinforced multiple times, I think, by all the speakers. But yeah, let Georgina.
Charlie, I mean, I have some
Actually,
simple.
I need you to identify yourself because we're.
Apologies,
Corporate.
Georgina Ariola for Perch Energy. So I can run, maybe just skip to some of the simplified bill samples that I was going to run through.
That would be
mine.
incredibly helpful. Thank you.
I don't have one that's specifically for NC2, but I can go over it since it actually mirrors the existing dual billing framework that exists. So let
Actually,
me-
if you could spell your last name for the court report, just so we got it
Of
accurate,
course.
and then
It's
go ahead.
EOLA. I'm sorry. ARREOLA. Thank you.
Okay.
Okay, so, sorry, just to level set here. So here's a comparison. Nope, that's the wrong customer. Okay, so here is a, where are we? Okay, so this is the NC1 model. You have your utility charges. This is customer with utility charges of $100. They're receiving a $100 bill credit. That bill credit is used to then pay off the subscription charge, which is comprised of two components. The 1% that will go to the utility is an administrative fee, and then the remaining $89 that are going to get paid to the SO directly. So what that does effectively is you take the $100 in the credit, less the $90 subscription charge. That's where you get your $10 net credit, which reduces that $120 charge from the utility, so the customer sees a $110 balance. So they get to take those savings of $10 directly on the bill. So that's the NC1 model. The NC2 model, so again, I don't have an exact NC2 slide here. 'cause that's
Can
not
you
one.
just stop for a second?
Yeah,
Okay,
of course.
So let's just start. Okay, so the customer sees a bill. It's $120.
Mhm.
There's a subscription credit.
Correct.
And that is because of the net metering piece of it.
It's going to be based on whatever share of the community solar project is allocated to the customer's account. Let's say they have 500 kWh. The monetary value of those credits in that month is $100. It's just whatever value is attributed to the portion of the generation for that customer share.
If I could chime in, Your Honor, that is effectively the net metering credit. So it would be calculated at the customer's full retail rate. So that's the initial sort of credit value that the customer receives on the bill as a result of being a subscriber. And then everything else after that goes into the payment to the utility and to the SO. And I'll hand it back over.
Okay, and so what determines how much is paid to the subscription charge?
Yeah, so the way it works is effectively the project selects a percentage, right? That's a subscription rate. That's effectively, like for instance, there's a minimum 10% discount under the permanent program legislation for LMI customers. So the project would select that amount. That would be a matter of, when contracting between the subscriber and the project. So they would pick that percentage, And then that subscription rate would then be used to calculate the subscription charge, right? So effectively, if you have a 10% discount rate, that means that the customer should save, as a result of the credit, should save $10 on the bill, and then $90 is to be paid to the project. So the net credit is effectively a 10% credit on the bill.
Okay.
And there can never be a cost associated with that.
And I did select 10% just because that is the mandatory minimum savings for an LMI customer. I think for all customers, they have to pay no more than the actual value of the credits, but at least for LMI customers, that is that minimum savings is 10%. So that is the example that I'm using throughout. Thanks for calling that out. So again, I don't have a specific.
So just one other question. So under the NC1 model, the subscriber organization would be paid first and would be paid in full.
Correct.
Okay.
Because that credit is used to pay off the subscription charges.
Okay.
Okay, Mr. Barbie.
Okay. Thank you, Mr. Chairman. So if I'm an LMI customer, I'm not going to see all of this on my bill. I'm just going to see $120 minus $10 equals $110, correct?
The regulations, Your Honor, that we've been working on with the work group, from from sort of a line item on the actual calculation of the amount owed, that's correct. So it would be sort of minus 10, like there would be that net credit. We did propose showing the other elements used to calculate that, so there would be transparency for the customer. But from a sort of end result perspective, they would that's the dollars and cents. It would be a reduction.
So the answer is they will only see 120 minus 10 equaling 110.
Effectively, yes.
Okay.
Yes.
So this, and I should know the answer to this, but maybe you can refresh my memory. These payments to the project, over what period of time will those payments occur? Life of the project, 10 years, 20 years?
Well, the payments, and this is the case for NC1, it's structured so the payments to the project only occur with respect to when there's actually an active subscription contract, right? So, what you see here, this would only occur, this is sort of a function of monthly utility billing. Every month this would happen. After the net credits applied to the customer's bill, the subscriber organization would be paid, but then to the extent that subscriber then unsubscribes, that would be unsubscribed generation. And then
my question is, I take it then that the utility administrative fee and the payment remitted to the subscriber organization is permanent for as long as that project exists, correct?
Yeah, it's a monthly, every month.
Okay, thank you.
And I guess one question for me. So the subscription charge for customers is the same for each member of a particular project, correct?
So Charlie with Coalition for Community Solar Access, it doesn't need to be, but it has to be at a minimum the 10% discount for LMI customers. But I believe the statute allows for flexibility for different rates for different customers. I think generally speaking for, I'm not with the subscription coordinators, they're going to try to streamline that into a, customer acquisition marketing standpoint of, all customers save 10%, 15%, 20%, whatever it might be. But, generally I think it will be pretty streamlined, but I think, if there's a commercial customer on there might have a different savings versus obviously an LMI customer. But an important caveat here, and we are going to talk a lot about this stuff, when we get into our remarks, is that HB 908 requires that customers never pay more as an element of their participation in the community solar program. So all customers participating, all customers that are using consolidated billing, they're never going to have a premium. This is never going to result in, their participation is never going to result in a higher electricity bill. It will always, by practice in the market, always result in a reduction. That's how the competitive market works. But HB 908 is sort of the belt and suspenders to ensure that that has to happen. Subscriber organizations cannot require like a premium basically to participate. LMI customers have a little extra requirement in that they get not only just at a minimum no cost, they get at a minimum a 10% reduction.
Fred,
So,
But what happens for the LMI customer, which is really the L customer, that receives LIHEAP support for the subscription fee? What happens there?
so I do have a bill example for that.
Okay.
And that's one of the concerns, which I'll get into later, but if you'd like to go over that right now, that's slide 6. At least the way that that would work under NC1, again, you have your utility charges, subscription credit, which first clears the subscription charge. After that, you are able to apply the LIHEAP credit. So again, you had the $10 net credit against the utility charges, so you still have $110 that are owed to the utility. The $350 is just a round number. I think the average LIHEAP electricity benefit for 2023 in Maryland was $363. So I simplified this a bit, but let's say it's $350 against that $110 that is owed. Essentially, for that month, the customer would owe $0 to the utility and retain a $240 credit. to
That's
use per month.
for LIHEAP, just for regular LIHEAP support. But
Correct.
we've been having conversations about using LIHEAP funding for the subscription charge. Would that have the same effect?
So with NC1, there is no change that's necessary to do that because the LIHEAP credits are still going to pay, regulated utility charges. So there's there are no changes that are needed on the state LIHEAP office. You're right, there is federal guidance to say that those funds can be used. We still haven't made any changes, but that would require each individual SO to become a vendor with LIHEAP, as I understand, and then find a way for either the customer to submit the SO charges to LIHEAP separately in order for the SOs to be paid separately. This is something that actually the NC2 proposal doesn't provide real clear guidance on and doesn't actually guarantee that we'll actually be able to get the state LIHEAP office to make those changes. But at least under NC1, because everything is flowing through to existing utility charges, it works as it would for a customer that is not on community solar.
Okay, thank you.
Thank you, Chair. Okay, I'll move now to statutory interpretation, legislative history argument. I think one of the things that we talked about just now was one of the fundamental differences between NC1 and NC2 is NC2 effectively has the utility acting as a payment processor where they're collecting the subscription charge and then remitting that once received to the SO. So that's a fundamental difference between the two models. We actually think that's a dispositive distinction when you look at the statute and legislative history behind HB 908. And once you analyze that, it's our position only NC1 and POR are permitted, and NC2 is not. And here's why. Under Public Utilities Article 7-306-2 G1 Romanet I, the Commission is required to implement consolidated billing by electric companies using either purchase of receivables or net crediting. Those are the two terms that are listed in the statute. POR is obviously permitted under the statute, and we think with respect to net crediting, only NC1 is the permitted form. Initially, when House Bill 908 was introduced, the definition of consolidated billing included only purchase of receivables protocols. So net crediting was not originally included in the bill. It was only envisioned that there would be purchase of receivables. Net crediting was not mentioned at all. In addition, as introduced, the definition of consolidated billing was specific that an electric company must, quote, remit payment received to subscriber organizations for monthly subscription charges to the subscriber organization. So again, it was very clear as originally introduced, the payment had to be received for remittance. This was all changed by amendments to the legislation that clarified specifically that net crediting could be used as an alternative to POR for utility consolidated billing. In addition to specifically adding net crediting as an option, the amendments included a key change. They actually struck the word received from the definition of consolidated billing. And you can see an excerpt of this on page 8 of CCSA's October 28th comments, where you can see the strike through where they remove the word received. So by removing the word received, it's our position the legislature clarified that under net crediting, there is no need to collect a subscription payment from the subscribing customer for a payment to be provided to the SO. With respect to how to read the statute, a basic and fundamental rule of statutory interpretation is that a law must be construed so that no word or phrase is rendered surpluses or meaningless. And the Maryland Supreme Court has actually gone further than this by considering the history of amendments to legislation when interpreting statutes to ensure the interpretation is consistent with the history of the amendments to the bill. So under that principle, the deletion of content from a bill needs to be considered when interpreting a statute. I think one example of this that the Commission's aware of is actually the perennial solar preemption case, where the Supreme Court examined legislation that was passed that when it was originally introduced would have clearly ended CPCN preemption. So would have removed the Commission's preemption authority for CPCNs, but then that bill was amended to include more ambiguous language that did not clearly end CPCN preemption. So in that case, the Supreme Court looked at the deletion and said, we cannot interpret this law to mean that the Commission doesn't have preemption authority because the General Assembly would not have amended the bill to remove something that would have ended that authority. So sort of a similar idea here. The General Assembly removed the word received, right? And NC2, that's a fundamental distinction. Payment would only be provided to SOs if payment is received by the electric company. So it's our position that the Commission cannot interpret the statute or should not interpret the statute now to effectively include the word received when it was removed by the legislature. I will add as additional support for that argument, Delegate Luke Clippinger, who is one of the primary sponsors of the bill in the House, submitted a brief letter indicating that the legislative intent behind this addition was to adopt a model like New York, which uses an NC1 model, not an NC2 model. So that's our statutory interpretation argument. I will say beyond this, even assuming that all three options are on the table, we believe NC1 is significantly better for all stakeholders, especially projects and LMI customers. And for those points, I'll hand it over to Mr. Kogashal.
Yep, thank you, David, and thank you, Chair Hoover and Commissioners. My name is Charlie Cogshaw. I'm the Mid-Atlantic Regional Director for Coalition for Community Solar Access.
And actually, could you spell your last name for him?
Yeah, Coggeshall, Coggeshall. Thank you. So I appreciate your time today and the opportunity to speak on such a pivotal decision that directly impacts the success and timing of the permanent program. My testimony today is longer than I usually aim for, but this is a complicated topic, as we've already acknowledged, and a critical element of the program. And the points that I hope you take away from what I'm about to tell you are that NC1 aligns with legislative intent. It's simple, transparent, been proven to work in New York. It's being implemented in New Jersey, where Maryland utilities already operate. Conversely, NC2 was never envisioned by the legislature, introduces unnecessary risk and complexities, and would undermine HB 908's equity goals. As David outlined, the legislative intent of HB 908 is clear. The bill's history, as well as Chair Clippinger's letter, provides strong justification for dismissing the utility's proposed form of consolidated billing labeled NC2. The legislature intentionally provided two options: net crediting, referred to as NC1, and purchase of receivables. These options aim to provide customers with a single bill while minimizing the risk of non-payment for subscriber organizations. These are important objectives tied to the permanent program. As Community Solar in Maryland moves toward a primary emphasis on low and moderate income participation. To be clear, NC2 was not considered by the legislature because it fails to achieve these critical goals. Beyond legislative intent, there are numerous advantages of net crediting over the other options. These advantages are already visible in New York, the largest community solar market in the country. And they also explain why New Jersey, a state similar to Maryland in its emphasis on equity, has adopted NC1 and will have it in place at the turn of the year. But before delving into those specifics of NC1's advantages, it's important to provide context on what's at stake. HB 908 is fundamentally about equity. It mandates that at least 40% of every community solar project's capacity be dedicated to low and moderate income customers. It requires residential customers to never see an increase in their energy costs due to participation, and that LMI customers in particular receive at least a 10% reduction. Projects are also prohibited from using credit checks for customer enrollment. Essentially, community solar in Maryland is evolving into a quasi-energy assistance program. Meeting these ambitious equity-focused requirements depends on implementing effective consolidated billing. As CCSA highlighted earlier this year in docket PC 59, consolidated billing reduces customer confusion and makes community solar more accessible to LMI households. It also minimizes collection risk for subscriber organizations tasked with enrolling and retaining the LMI participants. So that brings us to the development of consolidated billing regulations in Maryland. In April, CCSA volunteered to draft the initial regulations for the net metering working group. Before drafting, we consulted the Maryland utilities, PHI, PE, and BGE, to gauge support for using NC1 over purchase of receivables as the core mechanism on which to build the regulations. All three were supportive. In fact, PHI and PE acknowledged the efficiencies of aligning Maryland's program with their sister utilities in New Jersey, where NC1 is already required. But beyond those administrative efficiencies, NC1 offers simplicity and universal benefits to all stakeholders. Under NC1, everything flows from the credit value. The subscription payment, the administrative fee, and the net credit that benefits the customer are all derived from this single value. More specifically, the subscription payment is always a fraction of the credit value. For example, for LMI customers, the law ensures they retain at least 10% of the credit value, meaning the subscription payment cannot exceed 90%. The remaining portion of the credit, at least 10%, stays with the customer to reduce their electricity bill. Let me pass this around.
We have a handout. Chair, can I approach to distribute?
Sure. Do you have copies for, like, other interested entities that?
Yeah, we do, Your Honor.
Everyone's reading about the same.
Oh, I think they're all the same.
Yeah.
Thanks.
So I think this gets actually provides an example from a utility in New York, National Grid, where, as we've mentioned, net crediting, or NC1, is already in place, and it helps illustrate, I think, to the question Commissioner Barbe had about, what does this look like for the customer? We've proposed to have, transparency on the bills. That's our kind of recommendation from a policy standpoint, but also, to Commissioner Barbe's point, it's good to keep it simple. And so what this bill highlights in the top section, so this is on National Grid's website. You can Google National Grid example consolidated billing, and you'll come up with a page where they actually provide a nice example to show the customer how it works. On the top of the page, it shows in the highlighted section where the whole community solar transaction is occurring. The CDG credit is the community solar subscription credit of about $71. The CDG subscription fee is the subscription payment that's owed to the subscriber organization. That's about $64. You're left with about $7 as a net credit. On the highlighted section further below, it shows where that net credit is then taken and applied to the overall electricity bill, reducing it from what was $116 to now $108. And that's it. The process is straightforward, transparent, and guarantees savings with no hidden costs or surprises. Separate from the customer's experience, so moving away from the bill, separate from the customer's experience, the utility deducts its administrative fee from the subscription payment before sending the remaining amount to the subscriber organization. The simplicity is the cornerstone of NC1's success. For customers, the value proposition is clear and straightforward. There is guaranteed savings with no upfront costs and no strings attached. For utilities, NC1 reduces collection risk because the net credit helps pay down the customer's electricity bills, while also avoiding the administrative complexities associated with purchase of receivables. And for subscriber organizations, NC1 ensures they receive payments provided they maintain eligible customer subscriptions. This is particularly vital in Maryland, where credit checks are prohibited and LMI participation is required. So despite these clear benefits, some have raised concerns. Unfortunately, these concerns are often based on misunderstandings or misinformation. While there's not enough time to address every inaccuracy, I'll briefly address a few points. Most notably, the utilities claim that NC1 would create new collection risks to the utility and even risks to the customer. In reality, the opposite is true. As I've stated several times, thanks to HB 908, participating customers will never experience an increase in their overall energy charges as a result of their subscription. In fact, under NC1 and only under NC1, there would never be an unpaid subscription fee because the credit value would always cover the subscription payment. As David noted in the legislative history, the term payment received was specifically removed from HB 908 when net crediting was added, recognizing that subscription payments from customers don't occur under NC1. The New York Public Service Commission acknowledged this fact in their order adopting net crediting 5 years ago. The New York PSC stated, it can be assumed that any partial payment would have happened even in the absence of the customer's community solar subscription, and there is no risk that the amount of uncollectibles or the electric company's exposure will increase. So how is it then that the Maryland utilities are claiming there's a risk? My sense is that the utilities are driven by a preference for dual billing. Under dual billing, the entire credit value for a subscriber is being used to cover the customer's electricity charges, essentially eliminating the utility's collection risks for that customer, since nearly all electricity charges will get covered by the subscription credit. The utility proposal in NC2 mimics the dual billing experience. Not only was this not the legislative intent, but it would also introduce significant risks to the program and be completely counter to the vision behind HB 908. Under NC2, the entire credit value is first applied to the customer's electricity charges. The utility only passes payment to subscriber organizations if and when customers pay their full bills. This shifts collection risks onto subscriber organizations, forcing them to absorb financial uncertainty. To mitigate this risk, subscriber organizations are likely to target higher income customers within the LMI definition, undermining the program's equity goals. But it's worth connecting the dots further here. As noted by the New York PSC, given the credit value will always exceed the subscription charge, it's safe to assume that any partial or non-payment by the customer would have occurred in the absence of their participation in the program. This means that what is effectively being achieved by NC2 is a shift of the collection risk that the utility already had with electricity charges to instead be on the subscription charges owed to the subscriber organization. Subscriber organizations are not equipped to carry the utility's collection risks, particularly not in a program geared toward LMI participation. This issue is especially acute given HB 908's prohibition against credit checks for prospective subscribers. Additionally, NC2 complicates the customer experience. If a customer falls behind on their bill, the subscriber organization will be left with no recourse other than to pursue them for unpaid subscription fees, possibly involving collection agencies. This will undermine the value proposition and erode trust, especially in LMI communities already wary of predatory practices. The risks and challenges with NC2 are on full display in Illinois. I believe others here today will speak more about that experience, but I'll note that stakeholders are in the process of seeking a legislative solution in that state. Finally, adopting NC2 would delay implementation. This is not a minor point. Utilities are already cautioning that they may struggle to meet the 2026 deadline set by HB 908. Introducing NC2 would require a reset and an overhaul of the Net Metering Working Group's progress, further jeopardizing that timeline. I realize I've taken a lot of time, but as I mentioned, and as I think you all are aware and would agree, this is a very complicated topic, but also a very important decision. I didn't touch on purchase of receivables, but I'll note that while it could work, it's unnecessary and a distant second place behind NC1. Conversely, NC2 would not work and would fly in the face of legislative intent, including another HB 908 requirement for the Commission to implement changes that will improve billing and crediting processes for subscribers and subscriber organizations. As for the administrative fee, which is included in the petition, we believe the statute speaks for itself. and the Commission need not overcomplicate determining parameters around it. Ultimately, it's up to the utility to justify the costs attributed to consolidated billing. And if they think a reasonable recovery rate is needed beyond 1% of the credit value, then they can make their case in an evidentiary process based on substantial evidence. I would add that the utilities already implementing NC1 in New Jersey would gain clear administrative cost and resource efficiencies to align with Maryland's program. So in summary, as I mentioned at the top, NC1 aligns with legislative intent. It's simple, transparent, been proven to work in New York, unlike NC2, where it's failing in Illinois. And it's being implemented in New Jersey, where Maryland utilities also operate. Conversely, NC2 was never envisioned by the legislature, introduces unnecessary risk and complexities, and would undermine HB 908's equity goals. I urge the Commission to adopt NC1 to ensure Maryland's community solar program achieves its full potential and delivers on the promises of HB 908. Thank you, and happy to answer any questions.
Well, actually, so let me hear from everybody who's sort of on that side of the fence, and then we'll sort of ask questions of them. So why don't we hear from the rest of your panel?
Sure. Next up, we have Georgina Ariola.
Thank you. Good morning, Commissioners. Thank you for the opportunity. Again, my name is Georgina Ariola, and I'm Vice President of Policy for Perch Energy. Perch Energy is the second largest dedicated community servicing service provider in the U.S. We have over 700 megawatts of active community solar projects, including some here in Maryland's pilot project. My testimony reflects 6.5 years of experience managing all aspects of the customer life cycle in community solar, including customer billing. I've handled directly the challenges of dual billing markets, including reconciling utility and community solar bills, resolving discrepancies, and managing transitions in markets to consolidated billing. I now use that practical experience to help improve existing program rules and to ensure that when new rules are written, they're focused on outcomes, explicitly in providing the best customer experience and maximizing the likelihood of program success. So, to that end, today I want to discuss why NC1 represents the most effective and equitable framework for Maryland's community solar program. Again, I want to start by delving into the inefficiency and inequities in dual billing, and that's what some of these billing examples dive into. So the current dual billing framework is a significant barrier to success of community solar programs. At its core, dual billing is burdensome and inefficient for all parties, consumers, solar operators, and utilities alike. So the first bill example is just, a utility customer with no community solar. They receive their utility bill and pay directly. There's no savings for them to be had. Under the existing dual billing mechanism that exists today, a customer receives their utility bill. They again receive that $100 community solar credit, which pays down the utility charges. Now they have a smaller, but still remaining charges owed to the utility. And then separately, usually about 2 billing cycles later or more, they receive a separate invoice from the community solar provider for those credits at a discount. Again, here we're modeling a 10% discount on those credits, leaving the customer with a $90 invoice from the community solar provider. So in total, this customer does realize $10 in savings, but they do so across multiple months, so customers are left having to reconcile those 2 separate invoices and making sure that they are actually seeing the same numbers across 2 very separate things. For customers, dual billing, it creates unnecessary complexity. They receive 2 separate bills, again, one from the utility and another from the SO. The bills are often difficult to reconcile. This is a very simplified example. And they often require multiple data exchanges between utilities and SOs. Delays or errors in credit allocations lead to confusion, delayed benefits, and frequent bill corrections. Customers are left to navigate a disjointed process that makes community solar participation often feel more like a hassle than a benefit. Again, I haven't displayed any instances where those community solar credits aren't properly displayed or where we actually don't have community solar credits appearing on a customer's bill. Now, for low and moderate income households, the stakes are even higher. Dual billing is incompatible with energy assistance programs and payment plans that many LMI customers rely on to manage their energy expenses. The customers often face unpredictable billing cycles and higher energy burdens than they would without community solar. I think this is an unacceptable outcome for programs designed to promote equity and accessibility. The next example is for, again, an LMI customer. This is a customer who is not on community solar and can use those LIHEAP credits that we talked about previously to pay down their utility charges. In this example, as you see, those LIHEAP credits pay down the full utility charges. They have remaining balance that can roll over into future months, but that customer would owe nothing. By comparison, in our dual billing scenario, again, the utility takes the community solar credits, pays down their balance immediately, leaving only a $20 balance, again, that's owed to the utility. Then those credits are applied, meaning only $20 of that $350 benefit gets used, leaving $330. But giving this example, at a $20 a month rate, that could potentially leave over $100 of unused LIHEAP credits that this customer could have benefited from. And that customer is still going to receive that separate bill from the SO about 2 months later for those $90. So in essence, that customer is paying $90 for that month when in reality they would have paid nothing. Again, the dual billing mechanism imposes financial and administrative burdens on SOs in markets like New Jersey and Massachusetts, where currently we're still on a dual billing framework. Projects must enroll at least 50% LMI customers. SOs are responsible for collecting unpaid balances, which often results in revenue losses if a customer fails to pay their bill for multiple months. This forces operators to remove non-paying customers from projects, depriving them of future savings and hindering the program's broader participation. Now, moving on to an NC1 scenario. By contrast, New York's new net crediting model offers a proven solution to the challenges of dual billing. By integrating community solar credits and a subscription fee into a single bill, New York has created a simple, effective, and equitable framework. For customers, consolidated billing is transformative. They receive a single, straightforward bill that clearly outlines the community solar credits and savings, eliminating confusion, building trust, and encouraging participation, particularly amongst those LMI households. Again, here's that NC1 utility bill where the customer can see their savings directly and they see those happening on the same bill cycle. It goes even further for a customer, again, who is receiving LIHEAP benefits under that NC1 model, because in this instance, again, we've seen this before, but that subscription credit, because it's clearing the subscription charges first, results in $110 that's still owed to the utility, which those LIHEAP credits are now used against. In this instance, NC1 allows the customer to again pay nothing to the utility bill, just like they did without community solar. But this time, the LIHEAP credits that are retained by the customer is actually more than they would have been absent community solar. If I can go back to the previous example, sorry, here it is. This first example, because they had a higher utility bill of $120, they only retained $230 for future use. Because they get to take advantage of that $10 savings in that month, this customer actually has $240, which they can use for later. So, again, apologies. Okay, so for utilities, the SOs, the model reduces administrative burdens. Utilities guarantee payments to SOs directly from the credits applied to the customer bills, ensuring financial stability and reducing the risk of unpaid balances. Additionally, the streamlined process has resulted in fewer customer complaints, as we're told by some New York utilities whom we recently met with. And while the model's 1% administrative fee has proven to be sustainable for utilities, I think the results speak for themselves. New York is the fastest growing community solar market in the country. Amongst LMI households in particular, who have embraced the program, appreciating the opportunity to reduce their energy costs without additional financial or administrative burdens. Maryland has the opportunity to build on New York's success by adopting the NC1 proposal, which not only mirrors New York's net crediting model, it leverages improvements and best practices developed over the last 4 years, offering an even further streamlined, equitable, and sustainable approach to community solar. As we've seen, NC1 simplifies the customer experience, ensuring everyone, including LMI households, can participate without undue burden. By guaranteeing payments to the ESSO, it aligns with the legislative intent of HB 908, and it integrates seamlessly with energy assistance programs, preserving and even extending their value, as this last example proves, for those income-restricted customers in a way that is transparent and will foster trust. By contrast, NC2, which will mirror that dual billing scenario because the utility risks get paid down first, creates unnecessary complexity and risk, jeopardizing the equity and efficiency goals of community solar. Under NC2, customer billing becomes opaque, as the solar credits are first used to reduce the utility receivables, perpetuating many of the problems of dual billing. Instead of a streamlined process, this proposal actually imposes new questions that are introduced, which would require new rules for how customer payments must be split between utilities and ESSOs, whether a utility should have a say in when a subscriber can be removed from a project and lose access to savings, when and how an ESSO may seek payments from customers separately. Additionally, NC2 requires utilities to manage detailed arrearage tracking and administrative burdens and increases the risk of errors or data breaches, in my opinion. For ESSOs, NC2 shifts the collection risk typically managed by the utilities onto their shoulders, and it discourages ESSOs from enrolling LMI customers, undermining HB 908's commitment to equity and access. These issues highlight why NC2 is not a viable option for Maryland. It is an unproven framework which poses more questions than solutions, delaying the implementation and putting the success of community solar at risk. You can look no further than Illinois as proof of this. So, in conclusion, I believe Maryland's choice is clear. NC1 offers a proven, efficient, and equitable path forward, ensuring the goals of HB 908 are met while delivering tangible benefits for customers, ESSOs, and utilities. In contrast, NC2 creates unnecessary barriers and risk, perpetuating the very inequities community solar aims to address. Let us learn from the success we've seen in New York and adopt a consolidated billing model that prioritizes simplicity, equity, and sustainability. I believe NC1 is not just the best option, I believe it's the only viable path forward. Thank you for your time, and I look forward to answering any questions.
Thank you, Chair. Next up, we'll have Alex Passanen from Solstice. He'll talk about his experience in Illinois with NC2.
Okay, and just one suggestion, to the extent you can, let's not replow the ground that's already been plowed by the first two. And
Understood.
Okay,
Thanks. Alex Passanen with Solstice Power Technologies, Passanen. I've been leading the policy team here for 2 years, and we were originally founded in 2014 as a nonprofit dedicated to expanding access to solar, and then a few years after spun off the subscription provider that I'm representing today. We've built a reputation for deep community engagement and serving low-income households. I'll try to keep this under 5 minutes. Solstice was the first subscription provider to manage projects in Illinois' Low-Income Solar for All program, which offers a 50% discount and incentivizes 100% of each project to be subscribed by income-qualified customers. In 2021, the Illinois General Assembly passed a bill that required the state's largest utilities to implement net crediting, which at the time was lauded as a huge step toward keeping up with New York's program. By specifically using that term, net crediting, the community solar stakeholders were trying to replicate the New York model, which was the only jurisdiction where that term was being used at the time. The utilities argued that the legislative language was not prescriptive enough, so the very same discussion we're having here today took place in early 2022 in Illinois. David and Charlie both already mentioned that HB 908 had that amendment to strike the word received, which was in an effort to avoid that lack of specificity issue that we had in Illinois. The Illinois Commerce Commission ended up approving NC2, but the explanation they leaned on for doing so was to quote language from the section of their Public Utilities Act that specifically covers the treatment of retail electric suppliers, even though community solar is a totally different product. The other key piece then was that even though the market standard across our industry, and as already mentioned, has long been to offer guaranteed discounts, there is a community solar program in Illinois that doesn't have a low income requirement and also did not technically have a savings mandate. Here in Maryland, as has been said a few times, the statute explicitly states that we can't charge customers more than the value of their credits in any month. That means there's no scenario in which a utility could ever be asked to pay a project owner more than the credit rate at which they are required to purchase that energy from these projects at. It's been almost 3 years since the Illinois Commerce Commission approved NC2, and after many, many delays, the utility's net crediting systems finally became available a few months ago. Solstice is attempting to manage one of these projects that just energized despite the uncertainties, and unfortunately we haven't yet seen a bill cycle report from the utility, so I don't have concrete data on the missing payment collections, nor can I confirm the exact issues we're expecting to face with the limited reporting. But what I can tell you is that immediately after it became clear that the Illinois utilities committed to NC2, developers in the state began asking Solstice to collect payment information from subscribers on net crediting projects. It really cannot be emphasized enough that the number one way to create accessibility to community solar is to no longer require that subscribers provide payment information. That is what NC1 offers. It allows customers to continue paying their utility bills exactly how they were paying them before, including with cash, which is common for unbanked households. Imagine someone signing up for a product that guarantees savings, and I explain they're going to get those savings right on their utility bill with no additional steps. Of course, that subscriber is going to be skeptical if I then also ask for their credit card number. Even if we collect payment info in Illinois and end up having to chase down customers to pay for uncollected charges, there's going to be complex accounting burdens for utility companies and us. There need to be a way to reliably communicate to the utilities when those charges are being collected outside of the utilities payment process. Net crediting is supposed to enable broad access to community solar, create administrative efficiencies. NC2, as we've all explained, is adding more complexity and disincentivizing projects from delivering savings to households on the lower end of the program's income qualified population. Finally, the big picture in Illinois is that their low-income solar for all program now requires that their new community solar projects use net crediting, which was decided with good intentions, but without an understanding of how problematic the current model is for projects. The result is that developer appetite in the program has ground to a halt this year. And even though there are additional funds on the way from the EPA, we expect no more projects to get built until this is fixed. The NC2 design is so detrimental to the financeability of these projects that, as Charlie mentioned, the Illinois General Assembly is trying to replace the NC2 model with an NC model right now. It's not ideal that the utilities would have to reshape their systems, but we want equitable community solar to get built in Illinois, and these projects are not going to get built without that fix. It's essential that NC1 be adopted the first time around here in Maryland, because if it isn't, we will inevitably be revisiting this conversation again soon. Thank you so much.
Okay, next.
Thank you, Chair Hoover. Next up, we have Scott Elias, Vice President of Policy and Market Development for Clean Capital.
Hello, my name is Scott Elias, E-L-I-A-S. I am the Vice President of Policy and Market Development for Clean Capital. I can assure you what I'm going to be talking about is a bit new. And I'm going to try to de-wonkify this and sort of just explain this in the context of how projects either will or won't get built and how they either will or won't be financed. As background, Clean Capital is a diversified clean energy company. We make strategic investments in all types of solar and energy storage. We are the long-term owner-operator, for instance, of the portfolio of projects serving Howard County, and we are planning to further invest in community solar in Maryland. And I really want to bring sort of an investment lens to this conversation. So CCSA has outlined why NC1 offers simplicity, scalability, and equity benefits. And from an investment perspective, NC1 is a model that lenders and tax equity investors understand and are comfortable in. To give some context, the way that these projects will be done is developers will need to find outside sources of capital. There's sponsor equity, there is debt, there is tax equity. Historically, community solar is a very risky asset that has been difficult to get lenders comfortable with because you have different subscribers and because there is subscriber churn. And so what the New York Public Service Commission did was it said they wanted to create consolidated billing, which they called net crediting, specifically because it reduces or eliminates the community solar sponsor, aka those funding the developers, reluctance to enroll customers based on creditworthiness or non-payment concerns. This single decision is why you saw New York have an explosion of investment in community solar, because investors were comfortable with this model. It was intentionally de-risking a commodity that was a difficult thing to finance. By guaranteeing that the sponsors receive payments each month, regardless of whether customers pay in full or on time, it created a predictable revenue stream that is critical to attracting private capital. So when the industry or environmental advocates say that consolidated billing is a way to expand accessibility to community solar or make it easier to finance, they are talking about net crediting. We're just using the term consolidated billing as a catch-all. But what we are seeing here is an attempt to undermine that exact model, which is what has attracted so much payment. And I want to emphasize what Charlie pointed out, which is that the Public Service Commission specifically noted that under NC1, any partial payment or non-payment would have happened even in the absence of the customer's community solar membership. Would have happened even in the absence. And that is because, as he said, you are actually having a discount on your bill. You are more likely to be able to pay that bill. So that means that the NC1 model does not provide additional risk for utilities, as they are going to claim. It ensures that subscriber organizations can focus on expanding access to disadvantaged communities, and it provides predictable cash flows for investors. And so if you look at this from a probability-weighted risk assessment, which is what investors do, there's a very low probability of the bad debt that the utilities are going to talk about. It is a very unlikely scenario that you will see significant amount of debt. But what you will see if you adopt NC2 is exacerbating financing challenges that I will say have been exacerbated in light of the recent federal election, and you'll be shifting non-payment risks back to subscriber organizations. The subscriber organizations, in turn, will raise the customer acquisition costs, which is the single most, the single biggest cost and concern for community solar. You will have a 40% LMI requirement, which is already extremely ambitious and of concern to investors, and you will make that risk even more magnified. And I mention this because there are very few investors that exclusively invest only in community solar as a product. For instance, when we go out and try to pair our sponsor equity with debt and tax equity, we often have to pair community solar with non-community solar. And what will happen is if we adopt NC1, you will make it so that the subscriber organizations charge more to the subscribers. You'll make it so that less investors will want to invest in community solar in Maryland relative to New Jersey and New York and the other places that are adopting this already created mechanism instead of trying to reinvent the wheel. And you will make it so that it's much more difficult for Maryland to meet its ambitious clean energy goals in the time scale that they are required to do so. So I'll just sort of conclude by saying financing drives the deployment. And the NC2 model will raise red flags for tax equity investors, for debt providers, whereas the NC1 model is something that we are already comfortable with. So that is sort of the option before you, and I really do encourage you to think about this from a probability risk-weighted assessment. What is more likely to happen? That the customers that are saving money will not pay their bills, and or that if you do put the risk back on the subscribers, that we increase the cost of capital, create more uncertainty, and make it more difficult to actually finance projects that are saving customers and ratepayers money. Thank you.
Thank you, Chair. To round this out, we will have Chris Callagher and Eric Wallace on behalf of Ampion.
My foot's asleep. Sorry. Okay. Thank you. Chris Callagher, that's K-A-L-L-A-H-E-R. I'm Vice President and General Counsel at Ampion. I've been at Ampion about 3.5 years. Before that, I spent about 15 years in retail electricity and natural gas, which is experience I think actually has some bearing here, which I'll come back to. I've been in the energy business for a long time. I try to think of these problems from the perspective of everyone involved. I think everybody's trying to do the right thing. I represented utilities back in Wisconsin many years ago. I was briefly, and I say briefly, at the Mass DPU, so I also appreciate staff's perspective. And so I'm really trying to understand sort of what's going on here and what explains our difference of opinion. But I also want to come back to the subscriber experience and really what it's going to mean for them. And the first thing it will mean, I just want to give I want to put some numbers to what we're talking about here, and what it means for the low-income subscribers of Maryland. If you look at a typical 5 megawatt site
and you look at the dollar value of the credits that will produce, and you take 40% of those credits, which is what will go to LMI subscribers, and you think about a 10% discount, that will be the net value of the discount that's given to those LMI subscribers. That comes out to, using the residential rate for BG&E today, granted there's some uncertainty going forward, that's about $50,000 a year in net savings to LMI subscribers for every 5 megawatt site. Over the 20-year period of that site, that's about $1 million. So that's about $1 million for every 5 megawatt site that gets developed under the permanent program in Maryland. Now, what's the potential for this program? I can tell you right now that among the community solar industry, Maryland is a very attractive market. And what difference will that attraction make? It could make a big difference. Now, I think a lot of sites are going to get developed in Maryland one way or another. I want to be clear about that. But incrementally, and from a velocity perspective, there could be 500 megawatts of community solar sites developed in Maryland. That would be 100 sites. That's $100 million of savings for LMI subscribers over the next 20 years. So that's what's at stake here. This is real money for real people, and we want to make it as easy as possible to do what the legislature intended, which is get those customers on those sites and start enjoying those savings. So, what do we think is going on here? What is the disconnect? And I think the disconnect goes a little bit back to what Charlie said in his opening. There's definitely a point of reference problem. You know, the most important question you can ask about almost any topic is compared to what? Every discussion I have with my college-age daughters lately, I seem to at some point say, well, compared to what? And I think what's going on here is that if you look at the status quo as dual billing, and you look at the allocation of risk of non-payment under the dual billing model, if that's your status quo, that is the model in which the risk of non-payment rests squarely with the subscriber organization. The bill credit amounts are used to pay the utility bills. The amount that if a customer makes a partial payment without community solar would have left utility bills unpaid, now leaves subscriber organization subscriber fees unpaid. So in that model, the risk of non-payment remains squarely with the subscriber organization. If that is your bogey, if that's your status quo and you're trying to preserve that status quo, then NC2 is very attractive to you because it's a very similar risk profile, right? The risk of non-payment remains with the subscriber organization. And if you say, well, if we do this other thing, there's a different risk profile, and now the risk profile is more with the utility, well, you think that's bad. You call it a cost shift. But here's the flaw in that thinking. Dual billing is not the status quo for the permanent program. There is no status quo for the permanent program. You get to decide what the permanent program is going to be like. And the legislature really told you what they think it should be focused on, and that is low-income subscribers getting benefits as easily and as quickly as possible in as large amount as possible. So the real point of comparison should be between the different models and no community solar. That is the appropriate point of reference. Now we're going to go, so there's the status quo. And I'm going to focus on situations in which someone pays less than their full bill, because that's really all we care about. If someone pays all of their bills in full every month, all of these models are the same, except in some of the models, the subscriber organizations pay a 1% fee to the utilities. But if everybody's going to pay their bill all the time, nobody cares, right? So let's look at situations where somebody pays less than their full bill. And I'm just going to make it easy. $100 worth of utility charges, $100 community solar bill, customer has $50. So in the current dual billing arrangement, utility bill is paid off completely. Customer puts their $50 to the subscriber organization bill, leaving $50 in arrears to the community solar, to the SO. So let's move on. So that's, again, if that's what you're looking to preserve, NC2 looks very attractive to you. But if what you're really comparing is one of these models to no community solar, remember, Right now, the permanent program is not in place. So nobody's on a permanent program site right now. Everybody who's ever going to be on a site is now in the no community solar bucket. So what bucket are you going to put them in? If you put them in the NC1 bucket, you have, again, a $100 bill credit with a utility charge of $100. The subscription fee is $90. You net out the subscription fee from the bill credit, and you get a $10 net credit. It reduces the payment to $90. The customer has $50. They pay that. They are now in arrears to the utility for $40. In the no community solar scenario, they pay their $50. They're now in arrears to the utility for $50. So first of all, in this situation, everyone is better off versus the no community solar scenario. The customer is in arrears $10 fewer. They've gotten the net credit of $10, and the subscription organization has been paid. Utility customer doesn't get dropped from the community solar site because the SO has been made whole. And this is the only scenario where everyone is better off than in the no community solar scenario. So let's go to the next one. Here again, you see with the NC2, this is the one that looks the most like the status quo. The community solar credits are applied to the utility charges. They take the utility charges down to zero. Subscription fee is presented. Customer pays the $50. They go to the subscription fees, leaving $40 in arrearage to the subscription coordinator. So again, that's the one that looks most like the status quo, but it's also the one that is ultimately unsustainable. I think this is a point that hasn't been made. Here's what's going to happen in the actual market, and I work for a subscription coordinator, so this is what we do. If someone doesn't pay their bill, we will take them off the site. This might look like it's an advantage. Oh, this is great. We get to apply the charges, the bill credits to the utility charges, and now it's up to the subscriber organization. We're now $40 ahead of what we would be, compared to no community solar. But we're going to take that subscriber off of the site as fast as possible because we have no way. We don't have all of the tools that the utility has to manage our arrearages, right? We don't have threat of disconnect. All we have is the ability to go out and just dun people for money. So we don't want to do that. It affects, as Scott said, it affects our financing ability. So we have to take people off sites as quickly as possible. Now, think about the ironic effect of this, okay? So we're talking about LMI subscribers. The legislature made it as easy as possible for us to sign up those LMI subscribers. Some people have talked about doing our due diligence. The legislature said just the opposite. They wanted to make it as easy as possible. Self-attestation will work. Geo-eligibility will work. So they want LMI subscribers to go on these sites, and they want them to stay on the sites where they can get those benefits. If you go with NC2, what's going to happen is you will be continually culling out non-paying subscribers, ironically, systematically removing the people who need those benefits the most. Think about that. I mean, that's really what will happen. We will systematically take people who had community solar for a month and didn't pay their bill, and we'll take them off those sites. They're back in the no community solar bucket, and they're getting nothing. So really, I think that's what this comes down to. When you look at all of the different parts of the legislation, the ease of enrolling customers for LMI. And I'm telling you, this is the most lenient standard there is in the country. We do business in all of these states. It's even more lenient than New York. New York doesn't have self-attestation, for example. It's about the same as New Jersey. It's far more lenient than the federal program. So the clear intention is to make it as easy as possible to get those LMI subscribers onto the sites, and we think NC1 is the only way to get them on the sites and keep them on the sites so that they can enjoy the full benefits of this program as the legislature intended. I know I'm the only one, along with Eric, standing in between you and Thanksgiving, so I will conclude for now. Thank you.
So that's your panel, correct?
we still have Mr.
Oh, I will keep it very brief. I think our panelists have covered a lot of great points here this morning and really emphasized the important decision for the commission. I think big picture, we're talking about a transition from dual billing to consolidated billing, and which of these models of consolidated billing is going to be the right answer for Maryland. And in recent weeks and months, we've been having a lot of difficult discussions about the path forward for billing system changes and implementing SB1 and figuring out what retail supply is going to look like. And there's not a lot of great answers in that discussion. I think by contrast, sitting here today talking about HB 908 and this program, the General Assembly built in guaranteed savings so that there is no increased risk by customers participating in community solar under any of these models for utilities or non-participating ratepayers, right? So the question is, which of these three models between NC1, actual net crediting, NC2, which is consolidated billing without the net crediting, or purchase of receivables, is going to be the best path forward for Maryland. And when we look at the language in the statute, the General Assembly was clear that they want to, under 7306.2 G1 Romanet 7, they said implement consolidated billing, and in doing so, take steps to improve billing and crediting processes for subscribers, subscriber organizations, and subscription coordinators. And if you apply that lens across this whole discussion, the obvious answer here is that NC1 is the only solution for Maryland moving forward. And time is of the essence, right? We're bumping up against the deadline for the permanent program here at the end of next month. The regulations are still pending. The work group, as Mr. Coggeshall explained earlier, back in the spring, started discussing the actual regulatory language that CCSA drafted. Instead of making progress at finalizing that and getting these rules on the books, we've been retreading this ground about which of these approaches to take. And transitioning from NC1 to NC2 or to POR would require a reset, going back and figuring those things out. At the same time, we're hearing from utilities that they won't be able to make the POR transition for retail customers for 12 to 18 months. So one of the benefits of NC1 that the utilities emphasized in their comments back in 2019 in New York was that it's simpler and easier to implement and could be implemented more quickly. And we've heard that in New Jersey, affiliate utilities are implementing NC1 now. I believe that launches at the beginning in like a month, a little over a month. Right, so let's take all that good work that's been done, let's bring it to Maryland, make this program work, and let's get, if we ask the commission, give the work group that directive so we can get back to work and close this out. Thank you.
Thank you, Chair Hoover. That concludes our panel. My understanding is we do have John Fiastra here on behalf of Arcadia who would like to provide brief comments.
Mr. Chairman, members of the commission, on behalf of my client, I'm here to speak for Arcadia, my client. So Arcadia, as meant.
So I need you to state your name and spell your last name for the court reporter.
Italian names often provide trouble to court reporters. Fiastro, Fiastro. So, Mr. Chairman, as I mentioned, my name is John Fiastro. I'm here on behalf of Arcadia. Arcadia manages 200,000 customers nationwide and 2 gigawatts of nameplate capacity for community solar. Here in Maryland, that is 142 megawatts across 119 different projects. So Arcadia is Maryland's largest subscriber coordinator. Arcadia contends that proper net crediting implementation, particularly net crediting 1, is the single most important change in the community solar permanent program and in this rulemaking. Arcadia has perspective. Arcadia operates in both New York and in Illinois. In New York, Arcadia manages 92,000 net crediting 1 type customers, and in Illinois, 22,000 net crediting 2 type customers. And through this experience, Arcadia can say with confidence that net crediting 1 provides a better customer experience and improves access to LMI households, as mentioned earlier, the intent of the legislation. The New York PSC agreed with the decision to move in NC1. I'll forego a quote that is within Arcadia's comments, but adoption of this model has benefits. And really, as Mr. Callagher alluded to, I have some statistics that I'd like to provide the commission in my comments here, and that is particularly in regards to LMI attrition. You see, Arcadia has customer data points in Maryland there is an LMI attrition rate for LMI customers of about 6% monthly. That's monthly in Maryland. Whereas in New York, customers under NC1 experience an attrition rate of 2.8% monthly. So if we attribute these rates and throw them out over the entire year, we have 72% annual attrition for LMI customers here in Maryland, and 33.6% in New York. Now, why is this significant? Well, as subscriber coordinators go out into the marketplace and recruit customers, it becomes burdensome, and the cost of acquisition escalates with every customer moving off those projects. NC1 presents this commission and the state an opportunity to create a more sticky environment for subscribers, where customer subscribers can stay on projects for longer periods of time and enjoying the 10% savings attributed and required under the statute. Now, Mr. Callagher mentioned the cost of acquisition and the drop associated with that. If we assume, and we know that here in Maryland, those who are in arrears for their utility are allowed a certain amount of time to make payment. So partial payments do not trigger immediate disconnect. That's not what we as a state have laid out. So a typical utility customer today has several months to make those payments. But if we were to continue either with the current model or NC2, that immediate drop means that the savings that would inure to and the benefits that would inure to those LMI customers actually don't any longer, right? They're dropped. And as a result, the savings over the period of time do not inure, which means that the total nut owed to the utility at the end of 3 to 5 months would be higher than if they stayed on the project. I hope these, so it should be noted that Oregon, New York, New Jersey's moving towards it. Massachusetts has legislation to adopt an NC1 model. Illinois has a bill in front of it to adopt an NC1 model, moving from NC2 to NC1. So it should be noted that this is where the country's going. And frankly, the example, as you've heard, Illinois today, who has an NC2 model, is moving to NC1. It should be noted, no state's talking about moving from NC1 to NC2, right? There's nobody nationwide who's like, you know what, we should make it more difficult and make it this way. So I'll conclude my comments. Customers benefit when they stay on projects for longer, but it's not just customers, all right? And when we talk about who's shifting the risk back and forth between utilities and subscriber organizations, ultimately, the customer benefit is best and in line with the vision of the General Assembly under NC1. The customer benefits, the SO and the industry benefits, and frankly, the utility benefits as well. So with that, I conclude my comments, Mr. Chairman, and thank you for the time.
And Mr. Chairman, before we step back from the dais, may I approach, and we have hard copies of the slides that we went over. We just wanted to hand those
Sure.
out. That'd be okay.
So actually, what I want to do is ask questions of this panel first, and then we'll move to the arguments on the other side. So as soon as he gets done, I'll start with you.
Okay. All right. So, okay, thanks. Okay, so let's take this National Grid example. So under the current dual billing situation, the bill credit now goes to the utility in terms of billing. Is that correct? So there are dual billing situations, and there's a credit. The credit is applied to the demand charge for the utility. Is that the
I think it would be to the entire electricity bill. So the
no? But
difference,
if you have dual billing now.
yeah. So no, where here we have dual billing
in Maryland.
Yes.
Okay.
Correct. So all they're receiving in Maryland is that CDG credit on their bill. They're just getting a credit applied to the electricity bill, and then they have a separate transaction with the subscriber organization.
Right. So the only the credit now is going to the utility.
That's correct. The credit it's
For the
placed.
utilities bill.
It's placed on the utilities bill, and then there's a separate billing process where the project will bill the subscriber directly for a portion of that credit value. So
Right,
they'll
so
like
for
a
the
discount.
subscriber organization now, they're not seeing that credit. So when they send the bill to the customer, that's going to be the full value. So for NC1, that's essentially changing what entity sees the value of the credit. It's going to go from the utility in terms of the demand charge to the subscriber organization.
Yeah,
I would actually, I would take some exception with that characterization. I know that's the way it keeps being characterized, that the subscription, and this is the way I think that at least we in the industry have come to look at. And I think this is what made the model so elegant to the New York Utilities first, who proposed it, and the commission. What they're really looking at is the transaction with the subscriber, right? So it's the subscriber that's paid the credits, in essence, to use to pay their utility bill, and then they owe the subscriber organization the subscriber fee. So if it's $100 for the credits and a $90 fee, that, if you look at it from the subscriber perspective, that's the transaction.
Right, but I'm actually looking, I understand the subscriber one bill, it's much clearer. I'm looking at this from the perspective of the subscriber organization on the one hand and the utility. And so you're shifting risk, essentially, because you no longer, the subscriber organization under NC1 no longer has the risk, because the credit value is going to be paid to the subscriber organization instead of the utility.
Yeah.
So the risk shifts.
Compared to dual billing, that's right.
Right. I'm mostly
Yeah.
just trying to understand sort of how things are changing.
I'll just briefly add, because that was in Illinois order adopting their version. That was like the head scratcher for the commission in Illinois. It said, well, if there was a collection risk for the SO under dual billing, of course now there's going to be a new collection risk for the utility under NC1. But that's not true, because the subscriber organization didn't have access to the credit value in the first place. So under NC1, the utility has access to the credit value. They can take care of that subscription payment, boom, boom, on the bill. There's no increased collection risk for the utility.
Right. Well, and the utility has decided under dual billing that they get the credit value applied to the demand charge. It's you can, if in situations where the utility owned the generation and also applied the demand charge, it really wouldn't matter. They would just get they would see the credit there.
Yeah, and I think one last point there, because this is kind of the line I think that the utilities will state, and that we heard in the net metering working group, is that there's this new risk. I think the way I think about it is that there's a reduced benefit. They had a huge benefit with community solar under dual billing, because that customer's collection risk just goes away.
Right,
But
your risk
under NC1, the benefit is smaller, but it's still there because
right,
the
but
customer
your risk does
reduction.
change. I mean, you have a risk now. You have less of
The
a risk.
SO does,
right.
sure.
Right. Okay. So that I understand this national grid bill that you provided. So at the bottom where it's sort of total charges. So so you have delivery services and supply services. Is any supply being provided by National Grid? National Grid is only providing delivery services in this.
No, in this scenario, the customer remains an all requirement supply customer of the utility.
Right.
And that's actually, it's a good time to make this point. We're not providing electricity. We are not providing delivered electricity to the customer. Not.
Yeah, and that's what I wanted to
Yeah,
clear,
exactly. These there are scenarios you'll see sometimes. It's possible they could have a competitive supplier.
Right.
But in this case, the delivered supply service is being supplied by the utility.
Right.
and
The customer is basically getting a value of community solar reflected in the credit value.
That's right.
So it's reducing the total amount so the utility is still providing both, so I guess this is SOS and demand charge.
That's right.
Okay, and so you're not requiring credit checks, but are you
Prohibited under HB 98.
right? Right, but is there ever a scenario where you would be signing up a customer that could not get electricity service for I mean if they never pay their bill, and so I guess there's never a situation where a utility can't.
Well, they wouldn't have utility. This is one of the great ironies of this.
So it's always a customer that is currently has utility.
It would
service.
need to be an
Yes,
active
they have
customer.
good
All right,
enough
that's
credit
kind of
to
my-
get utility service.
Right. That's kind of so the utility is still going to always have their own risk of non-payment. It's just that they were able to use under dual billing. They're able to use the credit value to reduce the customer's burden to them.
Right. That's
Okay.
right. And under NC 1, the burden's still getting reduced, just not as much.
Right.
Because they're still got a net credit that's reducing that electricity bill. But under dual billing, it's a credit that could completely wipe away what's owed to the utility, and then they have this separate transaction they got to deal with the SO.
All right, I feel like I know things better,
Right, yeah.
or maybe I don't. All right, that's all I have. Thank you.
Thank you.
Commissioner Richard.
I think you all did a very good job going very, very thoroughly through all the points and the questions. I guess just if I were to try to, as I'm looking at some of the arguments made by OPC and staff and the concerns about possible adverse impacts on a ratepayer and getting disconnected and an overall ratepayer equity, I guess I just want to, if you have anything additionally to add, maybe I should add, because you have gone through, I think, some of those points, but it is something that we do have to weigh. And then on the other side, just how the program is functioning now, because while perhaps we could do better. My understanding is, I'm just looking at some of the data from Maryland Energy Administration. It looks like we have over 90 community solar projects up and running now, and 61 under construction. 156 projects are in design. So that would seem to indicate that even under the current circumstances, the program is doing, pretty well, and maybe is moving as quickly as possible. So if you could, again, correct any misimpressions I might be getting from that data.
Yep.
Because, personally, I have community solar, and it's been a good experience, but I do understand why we want to move to
You pay your bill, though, every month, don't you?
I certainly try.
Yeah.
It's just automatic. It goes through the credit card, and that's just it's seamless.
Yeah.
And then I get an accounting from the utility from BGE, what I've done, and I've also am a real net metering customer, and so I'm experiencing this. I'm just trying to understand where the improvement will be from the current situation. Understanding, yes, the legislature wants us to move toward a billing.
Yep. Yeah, Commissioner Richards, it's a good question, and I'm glad that you've flagged it. I'll briefly just say, with regards to kind of where the program is, where it's going, you're right. It's doing well. Most of the capacity, if not all of it's been reserved under the pilot program. I would say that the LMI bucket, it's kind of broken into these three different buckets of capacity. The LMI bucket, my sense is always kind of the last one that developers go after because it's the most difficult one. I think there's support from Maryland Energy Administration on that front with various incentives, but I think it's a challenge. I think the LMI portion, which is most similar to what the permanent program is going to look like, is a challenge under the pilot program because it is dual billing. So consolidated billing is a critical kind of like enabler for LMI participation. The permanent program is all about LMI participation, and so that's like the big distinction here on sort of the bridge of pilot to permanent, and consolidated billing being a facilitator of what is going to be a very different landscape for all of the projects that are going online and are being financed. But to the question on OPC and staff. My sense is OPC is kind of like wavered here a little bit the more they've understood. I do think that the net metering working group discussions just went round and round and round. It was pretty painful for several months there, very long discussions, and I understand sort of the due diligence that was going into them, but it was very easy for utilities to make remarks like, well, this is going to increase the termination risk for these customers. And that's an alarm bell, obviously for People's Council. It's an alarm bell probably for staff. For others, I think it was an alarm bell for Illinois Commission. But it's not sort of it's not accurate, and it's frankly not true. It's based on this comparison of dual billing versus NC1 as opposed to a non-community solar participant versus a community solar participant, which is what Chris was getting at. I think, and as I mentioned to Commissioner Sexton, like the way I think about this, it may seem like it's a new risk to the utility, but it's not. It's just a reduced benefit that they're getting from a collection risk standpoint when you're comparing it against dual billing. The reduced benefit is to the utility in the form of a reduced collection risk, but it's not a reduced benefit to the customer. I think that they're like thinking from the customer's perspective, the argument that community solar can offer can increase or cause sort of a termination risk, I think is short-sighted and it's not realistic. Because if you play it out in your, under an NC1 or NC1, sort of scenario, the customer's risk of like not paying their bill, as Chris and several others have alluded to, for a subscriber organization means they're out. Like, that's it. Yeah. We're not going to let that customer stick around. The utility is going to give them more time to not pay their bill.
I think the concern would be that if they don't pay their bill, they're going to lose their electricity. Now, I heard Mr. Fiastro say that it would take potentially a couple of months, but I think that's the concern that...
Well, I think last part, because I think I faded there a little bit, but I think it's as a sort of a core of the community solar program. The community solar, it's not sustainable to kind of view the community solar program to ensure that the utility has no collection risk with these customers. The subscriber organizations can't shoulder that entire burden. It's not sustainable for the market. It's not good policy. And as I say, it'll just result in customers getting dropped or subscriber organizations trying to figure out, like, how do we target the higher income of the LMI definition customers to reduce the risk of that happening. But it really is a shift of what already was a utility burden of collection risk onto the subscriber organization.
I just want to build on that in two respects. One thing.
The question really was around it seems like the program is doing very well in Maryland right now. We have some numbers to support it. But am I hearing you saying there's like a headwind or something?
Well, here's the current program. Only one of the buckets is LMI, and it's a 30% requirement. Okay. And we are allowed to do things that we are not allowed to do in the permanent program, and we can credit screen. We have to credit screen. We have to get payment information, and that part is very, very hard. In any market where you have LMI customers that you are going to dual bill, that you have to get payment information for, that is the most challenging part of that market, and it is the one that financiers and developers are least interested in. So the rest of the program may look great, but I can tell you right now, if the permanent program is every site is 40% LMI, and there's payment risk with respect to those customers, this program is going to struggle. The second thing, and I think this is critical to OPC's position, I think, the assertion that disconnection risk goes up in the permanent program with NC1 is 100% false. It's false. All of the subscribers who are going to be on permanent program sites are not on community solar. So the only fair point of comparison is what happens under NC1 compared to no community solar. The risk of disconnect goes down because their utility payments go down by the net discounted amount. That's the reality of the situation. The risk to customers is lower under NC1 compared to no community solar, which is the appropriate comparison for the permanent program.
And Commissioner, if I may, just because I want to directly address sort of your question about the reason, just to be clear, financing a pilot project is a very different risk profile than financing a new program effectively, where you as a financier have to basically decide you're okay with the fact that you can't do any sort of credit checks. You have to be okay with the significant increase of capacity that has to be allocated towards those LMI customers, and a lot of the sort of interest, to mitigate sort of the difficulty in financing when there's such LMI offtake. And I don't mean to be, to be disrespectful to sort of LMI communities, but it's much more difficult to get capital to invest in sort of favorable terms when you have that type of risk. You are right that you are, in a certain sense, moving risk over from the SOs to the utility. However, the difference is, whereas there's a real risk for third parties to finance it, you're shifting the perception of risk that raises financing costs over to the utility without actually increasing the risk of non-payment to the utility. So it's sort of a fundamental difference between whether or not the SOs and then in turn the developers and the financiers are taking on more risk, or whether that risk is inherently baked into the utility because they're the ones that already have that risk to begin with. And I would just also say to what's going well, I do think it is worth noting that in the net metering working group process, some of the utilities who are now saying they want NC2 did specifically talk about how they are comfortably adopting NC1 within New Jersey. And so I do think it is worth thinking about the economies of scale and optimization with utilities sort of implementing this across multiple jurisdictions.
Okay, thank you. And actually, I see Ampian. I was going to ask a question specifically about Illinois. We've heard about the fact that we have affiliate companies in New Jersey. We also have affiliates in Illinois. Do your companies have any experience specifically with the NC2 process? I mean, do they have systems in place that, if that were the direction we went, that our companies could pick those up, or would they have to be developed?
So their systems are in place as of a few months ago. Like I said, the legislation was passed in 2021, and it took over 3 years to get those up and running. And actually, part of the reason I didn't go into this in my comments was because the utilities originally there were designing it as NC1, and that's what they were communicating to us. We were already enrolling customers on this one project that just turned on. We were enrolling them without collecting payment info because we were under the assumption, we were told by one of the utilities, that it would be NC1. And then they backtracked and redesigned their system to implement NC2 instead, which obviously caused huge confusion for our customers. Our partners were saying, well, can you go back to those customers and get payment information? We were saying, no, that's a terrible customer experience. It's not what we were planning on offering. I don't have data on how that payment collection is going. Obviously, we're very concerned about all of that. The risk profile is going to align with what Scott is saying, is the risk profile is higher because serving these customers that are generally less likely to pay their full bill, they're more likely to be in arrearages, even by small amounts. We have had this project. We've been trying to turn this project on for over 2 years. It just turned on. It's had 2 cycles of bill credits go to the customers. The utility still hasn't given us a host report that basically says, hey, here's the credit that applied to each customer's account. Here's what we collected. So I can't speak to how poorly that's going to go. I can only say that it's taken forever to stand up, and part of the reason was because they were flip-flopping between these 2 mechanisms.
I do have experience in Illinois that might be relevant. So just to be clear, the standard community solar program in Illinois has no LMI requirement. It does have a 60-40 mass market to commercial split, to large customer split. And here's what happened in Illinois when they implemented NC2 compared to New York. For mass market, it's either residential or small commercial. The developers that we work with in Illinois who are operating in the standard community solar, they don't do any residential at all. They do all small commercial because of the credit risk, because of the payment risk associated with NC2. Whereas in New York, it's the same 60-40 split. Mass market can be small commercial or residential, and we do plenty of residential. So the only residential that you're going to see in Illinois is if somebody gets a low-income community benefit, 20% ATC bonus in Illinois. There is a LMI-specific program in Illinois that I think Alec is referring to, but in the other program, you're not going to see any LMI subscribers on those sites.
And I will just reemphasize that Illinois is in the cusp of likely passing legislation to directly change NC2 into NC1 for the reasons that are described so far today.
I do think it's worth noting, just in my experience, in New York, when the NC1 proposal came online, every site that was eligible to convert to consolidated billing did. And that directly increased the number of residential customers that we were signing up. Similarly to Ampion, in Illinois, the sites that we have, we are enrolling small commercial customers for that small subscriber bucket, not seeking LMI customers unless that site has the federal ITC 20% adder. And even then, we are, again, like Alex said, that offering was supposed to have been rolled out a year ago. The month before it was rolled out, they told us, oh no, sorry, we set it up not as NC2, but NC1, so you have to go back to the drawing board. A year later, they had told us it would be about a 4-month delay, maybe. A year later, sites are just turning on. And when we ask questions about what's going to happen with, partial payments, how can we track that? At which point, how long will you try to collect for, or how do we track payments? We don't have answers. We don't have manuals that specify that, and we don't even have sample reports to guide us in those scenarios.
Great. Well, thank you, and I appreciate you all being here today, and thank you for the investments you're making in Maryland. This is an incredibly important program that we make sure we get this right, so I appreciate your testimony.
Thanks for having us. Yeah.
Commissioner Barbe.
No questions. I want to hear the other side.
All right. Well, actually, I got a few. So right now, the NC1 process is in place in New York and being implemented in New Jersey. And anywhere else?
Well, legislation was just passed in
No, I
Massachusetts.
want to find, so who's currently using it? I'm not concerned about where it might show up, but where is it currently being used?
New York is where it is currently being used, and also where it was first established. The term net crediting was actually introduced by the utilities in New York because they wanted to do a process different than purchase of receivables.
I believe Oregon as well.
I'm not sure.
And
Okay.
yeah.
And-
Minnesota, we'll have to get back to you on Minnesota.
Okay,
as well.
and the NC2 one is currently being used in Illinois, but in anywhere else?
Not that I'm aware of.
Okay, all right.
I cannot tell a lie. It's used in Dominion.
In where?
Dominion? Isn't it used in Dominion?
Virginia?
There's a.
Sorry, I have to be
I'm sorry,
truthful.
I'm just trying to clear the record. So this discussion that you had earlier about the legislative intent, I know at the federal level, we have this ability to use the congressional record as a way of, demonstrating what the legislators intended when they wanted to do something. But, in Maryland, we don't have that, so we have to sort of tell by sort of actions. And I understand your discussion about, how you think the General Assembly was making changes and why they were doing it. And we have the letter from Delegate Clippinger, but we don't really have any explicit explanations within the bill or any of the supporting documents to say explicitly that's what they wanted to do on this, correct?
Well, I guess at a basic level that is correct. But again, our argument, I think the amendment speaks for itself, right? Because when the General Assembly added in net crediting as an option, they also removed the requirement that payments received before remittance to the project. So we think it's clear, because they were tied together, that that's what was happening. But I think you're right. It is a judgment call for the commission to make. We think it's a compelling argument, but
But it was a very intentional amendment, and we were part of that process. And the removal of that word, so receiving does happen in purchase of receivables. It doesn't happen in NC1. It does happen in NC2. And the word received was removed from the statute because we were looking at New York, talking about NC1. I'll also just add that we had talked to commission advisors during that session before we even made amendments in the legislation. We talked to the utilities. We connected commission advisors with staff at, I believe, NYSERDA in New York to talk about the New York program. It was very clear that we were looking at New York programs as the model that was being considered for the HB 908.
And I want to connect that to your initial question about where is there net crediting and where is there not. The question of consolidated billing is one that is actually, unfortunately, not one that is very common in multiple community solar programs. And so when entities like ourselves were advocating to the legislature about the need for net crediting, we were not talking, obviously, in detail the way we are today in such a wonky fashion, but the arguments that were used to persuade the legislators included the ease at which this would create a greater pool of financing and the ease at which this would simplifies the customer experience for LMI. And so while, yes, there is not necessarily a written trail that demonstrates this was the intent, I would encourage you to consider that many people supported this amendment under the assumption that we were talking about the New York style of net crediting, with all the details, maybe being reduced to platitudes and rhetoric.
There is a written record if we want to look at just emails and connections that were made with New York for utilities and for commission advisors.
Okay, so regarding the risks that you may take on if someone doesn't pay the bill, and a couple of times you've alluded to the fact that you can't do credit checks, but if I remember right, when this concept was originally being proposed for the adoption of first the pilot program for community solar and then later the permanent program, it was your industry that was looking for the self-attestation methodology, and essentially you sort of gave up on the idea of doing credit checks as a way of trying to get this through.
Well, the HB 908 prohibits credit checks. So we're not, subscriber organizations are not allowed to do
I
credit
understand
checks.
it, but my argument is that that was actually part of the deal that you guys accepted for this going forward.
Well, part of the, yeah.
Right.
It's good policy to not be digging into a customer's background, asking them to provide financial information. That's also good policy to have self-attestation, to take them for their word. So that's best practice policy in the
understand.
country.
So I guess what I'm trying to get at is, to a certain degree, you've kind of assumed this risk.
Well, I think the assumption of this risk is assumed with net crediting. I would argue that most financiers and developers didn't realize we would have this sort of debate pushed by the utilities to create the NC2 model that didn't exist at the time of this.
In both purchase of receivables and NC1, they contain the risk. So those are both viable. It works. We could do purchase of receivables. It's just more complicated and it's unnecessary because, as we keep saying, the subscription payment has to be less than the credit value. So there's no reason to have kind of two exchanges of dollars when it can all be kind of spliced apart with the credit value.
And Mr. Chairman, I would add that you can't. The self-attestation has less to do with the risk element and more to be able to demonstrate compliance with the 40% participation rate, right? The onus of qualifying that customer, making sure their LMI is greatly reduced by self-attestation. I would not conflate risk tolerance and self-attestation. They're there, you're right, but they're not. We're not on the same page of the hymnal with those two pieces.
Okay. And the bottom line is, so the charms of the NC1 method is the timing of when you get the payment for the subscription charge, and the fact that the collection risk remains with the utilities, who have the ability to terminate somebody's service, whereas if it's the other method and you're required to do the collection activities, you can't terminate service. The most you can do is cut the person from the program and engage in other collection activities that other businesses do.
There's some aspects of that, but you also have to look at the goals of the program, right? The goal is to have a 40% minimum LMI requirement, to specifically focus on low income, right? So it's a whole package. And so NC1 is a solution that allows that to work while also maintaining a 40% LMI requirement and the prohibiting credit checks. So it's really a whole package. You have to look at the benefits to all parties. It's administratively simpler, so that benefits all parties as well. There's a bunch of different benefits that go a bunch of different directions.
Well, there's another benefit that we haven't talked about, which is that the green power is going on the grid, right? I mean, that's what the program is. It's like we're not just any other business. The site has been built, it's operating, it's putting renewable energy on the grid, and the way that the developers pay for the green energy, they pay for the project, is by selling bill credits. That's how they do it. So it's not like we're trying to get away with something. This is one of the things that sort of puzzled us about some of the reaction to the program. It's like we're not trying to put something. This is not retail, right? This is not retail. We're not trying to put something over on people. The deal is people build sites to put renewable energy at the distribution grid, and they pay for it by selling bill credits for less than their value to subscribers, 40% of whom are LMI. So we're not like other businesses. We are not trying to put something over on people. We are trying to do two different positive things for Maryland. Put green electricity on the distribution grid and give savings to LMI subscribers.
Well, actually, okay.
So, well, okay, so I'm still sort of trying to get my head around this, but it seems to me, and maybe you can have a reaction to this, that that the credit value on some level really does relate to the subscription fee. I mean, you have a fee, and then you're telling the customer there's going to be a credit value that is higher than the fee, and so you will see a reduction. And so the two are sort of are really connected. When you have dual billing, on some level you sort of disaggregate the value. So on some level, the credit value is going to the wrong place.
Yeah.
It's going to the utility to reduce. Ultimately, and the customer is going to pay the same amount, but keeping the credit value connected to the subscription fee really sort of on some level makes sense because one is directly related to the other, as opposed to having that credit value being applied somewhere else.
That's right. No, I think that's exactly right. That's how I think of it. Also, and that's how the New York Bill National Grid example I provided sort of shows that, where that whole their participation in community solar is handled within that transaction. It's all handled underneath the umbrella of the credit value.
Well, and then the customer seeing two bills, it's probably actually on some level more confusing.
For sure.
Because you're seeing, well, wait a minute, I'm getting a bill for my subscription fee. Where's the value?
I'm a customer of Community Solar, and I can assure you that having the two dual bills in DC has made it more confusing for me to actually see whether I'm saving money, and I work in the industry and would need to do a spreadsheet because it's not always simple. I would also add, you asked, I think your question is spot on in terms of the value of the credit, and the utility customer is still paying the same amount. The question, that the real difference between NC1 and NC2 is not whether or not the customer is paying the same amount, it's whether or not the SO, the subscriber organization, is made whole in both terms, and the frequency and term in which they're being paid.
That's what you care about. But for the customer is going to care about
it's not
the
just
bottom line. But it just seems to me that where the credit value is not directly connected to the subscription fee, it gets confusing.
Yes, it's not just that that's what I care about. It is how you get investors to invest in what is a relatively risky asset with high LMI requirements, some of the most ambitious LMI requirements in the country.
Yeah, no, but I'm thinking about it from the ratepayer's perspective, because that's.
But it doesn't change the ratepayer's.
But what I'm saying is tying the two together. To me, it seems like that it's clearer for the ratepayer to understand how they relate.
Yes,
correct.
Okay. Yes, definitely. And I'll just note that NC2 disaggregates it, because potentially customer doesn't pay their subscription payment on their bill, then the subscriber organization is going to come after them outside of the billing process.
And then they really won't.
And then it goes back to dual billing. Essentially, you get two billing processes that are happening in parallel.
And the other point from the customer's perspective that we talked about towards the beginning of the hearing was there's this question about if they're on budget billing or if they're getting energy assistance benefits, how does that all play into it? NC1 simplifies that. Because you don't have to figure out how to handle that accounting. You're putting the credit and the fee together right at the beginning, getting a net credit, and then everything else continues the way that it does today on the bill.
Okay, I think we've heard enough on this side, so let's move on to, and I take it the lineup on the other side is utilities, OPC, and staff, correct? Okay, so let me start with the utilities, and and do the same thing. You want to, come to the table. So, I guess, is it just you, or is it going to be?
I was actually just looking, Your Honor, to see if I may be holding the fort here alone.
The blame on you too.
Go easy on me.
Yeah.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers, this time appearing for the Exelon Maryland Utilities. Appearing with me is my colleague Daniel Herson, it's also for BGE. And really what we want to do is, I think that the suppliers and their panelists, they gave an accurate representation of just how NC1 and NC2 were going to work from a technical perspective. Really what you as a commission, what you need to determine, and this is what we would like to clarify, and this also provides some additional context for the comments that we submitted, is where do you want the risk of if a customer makes a partial payment? And there was some discussion about this already during the first panel. And really just to back this up, and this is how I understood it, this was my eureka moment, was that you have to understand about how the subscriber organization fee, whether that is going to be on the bill versus part of the utility bill. Currently under purchase of receivables, the utility, we purchase the receivables from the supplier, it becomes our receivables. And so therefore, those receivables are part of the utility bill. If a customer does not pay 100% of their bill, that can go towards an arrearage, and as there was some discussion this morning, that can ultimately lead to the customer getting disconnected. In contrast, under NC1 and NC2, the subscriber organization fee is going to be on the bill, but it is not going to be part of the utility bill. So, once you make that understanding, then what the question becomes is, where does the subscription credit that comes from the community solar generator, where does that go first? Under NC1, as there was some discussion this morning, and looking at the example on National Grid, the credit will first be applied to the subscription organization fee. The result of that, and if you look at National Grid, is that if you start off with the credit of $71.38, that goes toward the fee first, which means that the customer will only receive $7.55, excuse me. That will only that portion of the credit will be applied to the utility charges. And that's important because it's the utility charges that will lead a customer to getting disconnected if they build up enough of a arrearage. Under NC2, that $71.36 will first be applied to the utility charges, and then whatever amount is left over, that will be applied toward the subscription organization. Now, NC2, that captures essentially what the status quo is right now. I know there was some discussion about this morning about how there is no status quo. I'm not sure if I agree with that. But right now, the risk of the subscriber organization fee not being paid is on the subscribers, on the subscriber organizations. And Commissioner Suchman, I think you hit the nail on the head. What would happen under NC2 is that risk would move from the subscriber organizations, not onto the utility. I think it's important to make that very clear. It's not to us. It is to our customers. It is our customers who run the risk, who would have to bear that additional cost that they don't have that risk right now. But they would have to assume that additional risk of being disconnected if they don't pay 100% of their bill. Now, we as the Exelon utilities, we don't believe that our customers should have to bear that additional risk. So, but that essentially is the policy decision that you as a commission have to make. Just to respond to two additional points that was made this morning, there was some discussion about the legislative intent under HB 908, and about how it is clear that under 908 that the fee was to be paid from the from the subscription credit that is generated by the subscriber organization. Well, and I'll confess I have not looked into the legislative history behind this amendment, but it still says that there's to be a payment. Even though the word received was struck, it still says that it's to be a payment. It's not clear from this language that the fee charged by the subscriber organization is to be paid from the credit. A credit is not a payment. A credit is something that's owed to the customer because they have signed up with the subscriber organization. So I understand the position of the subscriber organizations, but I don't think it is clear, at least not to me, that that was the intent of this legislation, just looking at the words that are here in front of me. Finally, I do want to just see if we can clarify. I heard some comments, and this was also in the written comments from the subscribers, about how they do not have the ability to screen customers under HB 908. I don't believe that is entirely correct. What the statute says is that a subscriber organization, and I'm looking at 7-306.2 L1 Roman I, where it says subscriber organization or a subscription coordinator may not require an LMI subscriber to undergo a credit check or to pay a sign-up fee. It does not prohibit across the board credit checks. So I just wanted to clarify that. So I hope that provides some additional context from where we are coming from as the Exelon utilities. And I hope it provides some clarity in terms of the policy decision that you as a commission need to make. Where do you want the risk to be? So with that, I'm available, and we have some subject matter experts available for questions as well. Thank you.
Well, again, let me
Sure.
sort of take all the utilities, then we'll sort of ask questions after
Sure.
that. So, Mr. Herson, anything you
Yeah,
want?
I don't have too much to add. Obviously, we agree with Mr. Seegers. You know, I like to try to keep this debate as simple as possible. I think you're being presented with two choices here. In our view, one choice makes it less likely that a customer who makes a partial payment is going to find themselves in a situation where they could be facing a utility service termination. And that's also the choice that makes it less likely that all ratepayers are going to bear the burden of an increase in bad debt. In our view, the other choice doesn't afford those two situations. So, you know, you've heard a lot from a lot of people this morning. To me, it's a pretty simple distinction, and that's what we're trying to convey.
So, anybody here from Potomac Edison? Alrighty. Actually, I mean, there's a chair there if you want to use that, or stand at the podium. Either way. So.
I know. Got to start wearing a disguise back there. Good afternoon, Jessica Raba, RABA, on behalf of Potomac Edison. We did not file written comments, Your Honor. I think Mr. Seegers summarized well the issue before you. It's a policy decision that you have to make, and there are merits to both sides. At the risk of being on an island, we do still think there is value in considering POR as an option. We're already set up to do that. It allows you the flexibility to shift the risk depending on how you set the discount rate if you were to go down that road, but understanding that we might be moving away from that entirely. I'll just offer that for Potomac Edison, from an administrative perspective, NC1 would be much easier for us to implement. But, you know, again, we see the merits to both sides.
Okay. And SMECO. There we go.
Mr. Krieger left, but I will say he would probably gloat that SMECO is exempt from the community solar.
Oh, that's right.
statute.
Yes. Okay, I forgot about that. That's why he left. So, okay. So, any questions for the utilities? All right, Commissioner Barbe.
So thank you, Mr. Chairman. Let me address a couple of the arguments that were made by the other point of view. And the one argument that was made by the individual who's representing an investing developer was that the NC1 model is one that de-risks investment and creates more of a climate for this kind of investment, as opposed to what's happened in Illinois, where he has said, I don't know if it's true, but probably it is, he has said that the other model has disincentivized investment. I wonder if you would care to respond to that.
I can't speak to what's going on in other jurisdictions, Your Honor. What I will say, and Commissioner Richards' discussion alluded to this, is that, as I said before, right now, the subscriber organizations, they have that risk right now. So it was a little interesting to hear them say about how they shouldn't have to assume that risk, because they already have it right now. And from what it sounds like, the community solar market in Maryland is doing relatively well. So I think that's how I would respond to it. So I'm sorry, go ahead.
Nope. Thanks for that answer. The second point that was made by somebody, can't remember the name now, was that the very fact that these LMI customers are going to be paying less money automatically lowers the risk of defaults and non-payment or large partial payments. If you're getting a discount, the probability of that is lower, and that ameliorates some of the concern you have with respect to partial payments and people being disconnected. How do you feel about that argument?
While it may be technically correct that a customer's bill may be lower by any amount if you automatically deduct the credit or the fee from the credit, the question is that how much lower would it be? Under NC2, the utility bill, and that is, once again, it is the utility bill that could wind up getting a customer disconnected from service if they don't pay those charges. Under NC2, it is the utility bill that will be deducted by the total amount of the credit. Once again, just looking at the National Grid example, that would be $71.38. Mm-hmm. Under NC1, it would only go down by $7.55. So that still places our customer at risk of disconnection for what is a much greater amount. So while it may be technically correct that a customer's overall bill would be lower, it is that portion of the bill, the utility charges, that would be reduced by much less. And that is what our concern is, because again, that's how a customer would get disconnected.
Okay, well, let me ask this question just to make sure it's in the record and it's clear to all of us. Under NC1, the customer gets one bill. Under NC2, the customer gets two, correct?
No, that is not correct, Your Honor.
Okay, how does it work then?
Under both NC1 and NC2, the customer will get one bill. This is not, and that's actually one thing that I do want to make clear, that our position has nothing to do with any kind of a preference for dual billing. Under NC1 and NC2, there will be one bill. Under NC1, the credit that is generated from the subscriber organization, the generator, that will be applied first to the subscription fee. So again, if on the National Grid example, if the credit was the $71, you would first take out the subscription fee, which in this case is $64, and that leaves you with $7.55. So once again, I started off by saying you have to look at one bill, but there's two things on there. There's the subscriber organization fee and then the utility bill charges. I think the challenge here is that we're all used to purchase of receivables. Under purchase of receivables, it's all utility charges. That's not the case here. So, I'm sorry, did you have a question?
No, go ahead.
Okay.
I do after you're completed.
Sure. So under NC1, whatever is left over from the credit, that will be applied to the utility charges on the bill. Under NC2, still one bill. You've got the subscriber organization fee and the utility charges. The credit will be applied first to the utility charges, and then if there's anything left over, it would be applied to the subscription organization fee.
Okay. Well, again, just to put it into the record, regardless of whether SC1 or NC1 or 2 are used, the mathematical bottom line is going to be identical in either the bottom line. What I, as the customer, will have to pay will be mathematically the same in both scenarios at the end of the calculation.
On a total bill,
Yeah,
that
on
may be
total.
correct, Your Honor, yes. But
No, it
like,
would mathematically have to be correct, would it not?
if you're looking at the total bill, yes.
Okay.
Yes, I think that would be correct, Your Honor.
So really, this is only a question, as you said, where we choose to allocate the risk. The question is who gets the money first, really.
Basically, yes, Your Honor. Yes. But like I said, there was a number of discussion about how it is a proposition between the SOs and the utility. What I want to make clear is that it is not us, the utility, it is our customers. So essentially, it
Right.
is where's the risk going to go, the subscriber organizations or our customers?
If I could address one point.
Actually, let me do this. I'm actually going to go through all the utilities, and then I'm going to go to OPC and staff, and then I'll give you a chance to, so just take
Understood.
notes as to
Thank you.
things you want to respond to.
Actually, given the fact, Mr. Chairman, that the subscriber organizations wanted to rebut what was just said, I'm just curious if you have anything they said that you want to directly rebut that I haven't covered.
That other than what I covered in my opening about the legislative intent and their ability to screen customers, and also just to make it clear that when we're talking about the utility, it's important to keep in mind that what we're really talking about here is our utility customers.
Right.
So,
Okay.
other than that, no, Your Honor.
Okay. Thank you very much. Thank you, Mr. Chairman.
Commissioner Richard.
Just thinking about something you said a minute ago about what our decision here and what the intent of the legislation is. It is a policy of the state to promote clean renewable energy, including solar. So in your discussion, you said it's a matter of where the risk is.
Correct.
So if we do anything to de-risk some of the, doing business in Maryland, the being able to construct these facilities, do you agree that that would promote these solar projects, these community solar projects?
I think it would make it, more inviting for projects to come in. But then you have to contrast that with, okay, there's been a lot of discussion about how the benefits of that could go to customers, but then you have to weigh that against, well, now customers have to take on that additional risk. And like I said, it is the utility charges that could get those customers, if they don't pay the utility portion of their bill, that they could get their service disconnected.
Yeah,
So,
there's certainly
but
that.
yes,
that
I
piece.
understand the
but again,
business.
but just again, going to your point, you agree that things we can do to again de-risk the business of building community solar would enhance that policy.
I
promote
would
that
agree
policy.
that less risky enterprises are usually more attractive to investors.
Okay.
That's, yes.
Yeah, and that's largely, I think, the utilities also. We do what we can to de-risk your business as well.
Yep.
So that ultimately you will get paid. So
Yes.
in the end, we're trying to promote state policies, and de-risking seems to be a key part of doing that. Would you agree?
It is one, it's a consideration, yes, in your overall, yes, in your decision making.
Okay, the only other is one concern raised is that NC2 could be very complicated, and it's not been tested yet. Do you have any comment on that? Is that a correct, again, analysis of our decision between NC1 and NC2?
I'm not sure I would agree that it would be like overly complicated. It essentially, the way that it would work is that we would get the subscriber organization fee from the subscriber organization. It would go on the customer's bill. We would try to get collection of that fee for a period of time. I believe that the amount of time that's been discussed is about 3 months. After that, it would go back to the subscriber organization. So, but just in terms of allocating the customer payments, that's something that, we're able to do like right now. For example, like under, in purchase of receivables, we have our payment posting methodology. So I'm not sure if I would say that it would be overly complicated.
Well, it sounds like there are more steps involved, and we've talked about this before. It seems like those steps involved the programming cost, all the different costs that go into the billing systems.
Mhm.
And so, with those additional steps, additional cost, are you saying that NC1, NC2 would be exactly the same, and that they could implement them the same cost in the same time period?
I cannot speak for the, well, actually, I was told that for BGE, it would be the same for the implementation costs for NC1 and NC2 in terms of of programming.
Mm-hmm. Yeah, no, I would agree. Just looking at my bill for community solar for BGE, it seems like you're almost already there for NC1. I'm just not certain. I can see how it would be as easy to go from what is being done now to NC2. But I guess I shouldn't be asking you. I should ask Mr. Herson.
Well, I should probably ask my subject matter.
Oh, okay.
experts. I don't know if they want to say something.
Good afternoon, Stacy Ono, last name ONOH from BGE. Just wanted to quickly mention that I know CCSA and other entities mentioned that NC1 is being implemented in New Jersey. I think the first thing to make clear is that BGE does not use the same billing system as our sister utility, PHI. And whatever is implemented in New Jersey cannot automatically be used at BGE, right? And the second thing is, for BGE, the IT costs, or the IT estimate for NC1 versus NC2 is roughly the same, right? The implementation costs and how we've estimated what that would be. So they're roughly the same. For PHI, regardless of the soon-to-be implementation of NC1 in New Jersey, there would still be a cost attached to that in Maryland. So just wanted to make that clear. It's not something that they can just pull and use in Maryland. There would still be a cost attached to the Maryland implementation of NC1. So when you look at it, there are costs either way. It's like Matt Seegers mentioned, is not more complicated in terms of the estimates. Is not that humongous compared to NC1. Is comparable in terms of implementation.
Okay, so that's the commitment from the utility today, because the legislature says we're going to have to do one of these.
Right.
And so the utility, Exelon Utilities are committing that no matter what, it'll be the same cost and the same time to do.
Well, we're saying they're going to be very comparable. And at BGE, we're going by very high-level estimates for the IT implementation, and there's nothing for right now telling us that NC2 is going to be much more expensive than NC1. So we're saying based on high-level estimates, both at PHI and BGE, we're looking at roughly comparable costs.
Okay, well,
And depending on what gets approved and how we have to implement it exactly, because we have to go back and determine what the regulations are and what the requirements are, whether it's going to be NC1 or NC2, and we have to come back with detailed estimates. So we don't have detailed numbers right now. We just know high level, and we think the costs are comparable.
okay, but not a solid commitment today that if we pick one or the other, there's going to be a cost savings or a savings in just how quickly you can implement this program.
Overall, we cannot commit to anything for either NC1 or NC2, to be honest. And I think I just want to go back to what's at hand here, right? So we're really looking at the customer, and we're really advocating on behalf of the customer. So, there are investment risks for the SOs and how they're going to be made whole, and we've had discussions about that. But how does it impact the customer, and how does it impact the ratepayers? So I think the commission really needs to consider, do we want ratepayers to fund community solar? Do we want ratepayers to fund LMI participation in community solar? I think that's the key question that needs to be answered. Because it's not a utility risk. The utility will not really assume the risk, right? We're going to recover any non-payment through our rate base. So it really goes back to the customers having to pay for any non-payment when it comes to community solar. And today, that risk, it lies with the SO, the subscriber organizations, and in future, if we go with NC1, that risk will be assumed by our ratepayers.
Okay, well, I appreciate your testimony today. Thank you. Thank you, Mr. Chair.
Commissioner Schlesman.
Okay, so let's talk about risk. And let's pull up the National Grid bill. It's actually really like that you provided this because it's actually really helpful to sort of see this in person. Okay, and let's take the yellow off. So let's just assume we have a customer that has not decided to go with community solar yet. It's just a plain old National Grid bill customer. But we could also call it a PHI customer because I'm assuming the bill looks sort of the same. Actually, I don't really know because we just get a bottom line and then we just pay it. But in that sense, the total electric bill is $115.92, right?
I'm sorry, Commissioner.
You've got electricity supply, you've got delivery services. This is at the bottom, summary of current charges.
I see. Okay, yes.
Okay, so that total bill is $115.92. Okay, so then we have a customer that decides to go with community solar.
Mm-hmm.
So then that piece gets added on. If that customer were a current PHI customer, so that you would take the credit and apply it to their bill, that would lower that $115 to about $80, correct?
Roughly,
Okay.
yes.
So it seems to me in that situation that the utility has a lower risk than it used to have by taking that credit and applying it to the bill.
By the utility, do you mean the customer, Your Honor?
I'm talking about you, PHI. You're currently applying the credit value to the customer's bill. That lowers your risk than if the customer were not doing community solar. The risk to you is not the same. You're actually, the utility has a lower risk currently in how you bill under a dual billing situation.
Well, and
maybe you can tell me that I'm wrong because I'm still trying to understand the whole risk thing.
Well, and that's what I want to make clear that when you say that our risk has gone down,
I'm talking about the risk of the customer being able to pay the bill. If the customer had paid $115 a month before they signed up for community solar, and they signed up for community solar, and you're taking the credit value and you're applying it to their bill, then the risk for the utility actually goes down, and the risk to the subscriber organization goes up because the subscriber organization doesn't know that they're going to get paid. You know that at least $71 of that customer's bill has already been paid through the credit value. So at this point right now, under dual billing, the utility's risk has gone down because of dual billing.
I would agree, Your Honor, that when a customer, when they subscribe to community solar and they get a credit and that goes onto their bill, as I'm talking about the current.
I'm talking about
right
the
now.
current situation.
The bill will be lower, which means that it should be easier for the customer to pay. Where I have a little bit of concern.
So just if we could stop there. So just in what you've laid out, the PHI's risk of being paid the full amount has gone down because at least you're going to get half of what you're owed. The risk to the subscriber organization has gone up because they don't know that they're going to get paid at all.
That's technically correct, Your Honor, but like I said, I want to make clear that the risk is not to the utility. If a customer, if they don't pay any part of their bill, that does not go onto the utilities. That would go into the uncollectibles that would get spread to all of our customers. And I want to make
But
it
actually,
very clear.
actually, the customer's exposure is lower. The subscriber organization's risk stays high. But if you take all the credit value and you put it on the customer's bill, then to the extent the customer doesn't pay their bill, that exposure is actually lower, not just for the utility, but for all customers. So the current situation actually, I mean, it seems to me that the subscriber organization is carrying the full burden of the risk by having the utility take the credit value and applying it to the customer's bill. The utility risk is lower, and ratepayers as a whole are lower, and the subscriber organization is carrying the full burden of the risk.
As it is right now, that's correct, Your Honor.
Right, and so it seems to me that the whole point of doing community solar is for the subscriber organizations to get these customers to sign up, and then customers to get some value from it. When you disaggregate those, when you separate those, then you really do. Then to me that doesn't make any sense at all. And then you create risks that shouldn't be there, or lowering risks that shouldn't occur. That's why it doesn't. I'm just sort of saying it doesn't seem to make a whole lot of sense to go to an approach that's other than NC1, because it just seems to me that I'm not seeing it. Well, first of all, I'm not seeing any increase in risk to the utility in a situation where the customer, where there's no solar. If you give the subscriber organization the full value of the credit, the only risk to you is to take away the lowering risk that you shouldn't have had in the first place, and it's just going to put you back to where you would have been had you not done this dual billing, where you would have lowered the customer's the customer's bill to you. Do you understand what I'm saying? So if there had been no dual billing and we had gone from nothing to NC1, then the utility would not have been affected, because you're not getting any of the value. You and the ratepayers are not getting any of the value of the credit, because there wouldn't have been any credit. And then it would have just gone to the subscriber organization. There would be no impact on utilities, because nothing would be any different than if you had just taken this bill and just gotten rid of this. I hope I'm being clear. I feel like I'm being clear to me, but maybe I'm not being clear enough.
I'm sorry. I'm trying to follow what.
So what you were talking about shifting risk.
Correct.
Okay, and I don't think that there's any risk on the utility had there been no dual billing, but you are getting a lower risk in terms of customers paying their bills currently by having the credit value applied to the bill. So all this is doing on some levels is just putting you back to stasis. You're not, there's no additional risk on you by just taking away the credit value that maybe you shouldn't have been taking advantage of in the first place, of applying it to the customer bill to lower the risk to you and other ratepayers. The customers going to not, as Commissioner Barvey explained, the customer's not going to see any difference. The bill's going to be the same, but the risk changes, I think, dramatically. And it just seems to me that in this instance, utilities have been getting a benefit to the dual billing situation that maybe shouldn't have happened. Maybe you can explain to me why that statement is wrong.
Well, it's just, I think the way to look at this is that the risk of the subscriber organization fee not being paid, that risk was always there. Right now, the subscriber organizations, they bear all that risk. The question is, and that is not going to go away under NC1 or NC2.
No, actually it does. I mean, if they're able to collect on the credit value, then their risk goes away.
Then their risk goes away.
But how does your
And it gets moved over to
that's what
the
you
customer.
that's what I don't understand.
Okay.
How does it get moved over? You had no risk in the beginning, then you took advantage of an opportunity to lower the risk. The bill is going to stay the same, except it's actually going to be a little bit less. It's going to go from $115.92, which was your original bill, to $108.37, which is the new bill. You actually have lowered your risk a little bit. But where is it that where is the additional risk to you?
The additional risk is because the utility charges, which once again, it is the utility charges that a customer, if they don't pay those, then they run the risk of termination.
That was always the case.
Correct. So, as it is right now, the utility charges would be reduced by the $71.38.
No. I'm talking about the total bill here.
Mm-hmm.
The total bill was $115 before community solar, and now it's $108.37. Your risk has gone down. What you're doing is you're counting that credit value that you were able to apply to the bill that lowered the risk of payment for the utility and for all of ratepayers. You got a huge benefit here that maybe you shouldn't have gotten in the first place. So all I'm saying to you is if you take that off the table, if there had been no community solar, there'd be $115.93 payment that the customer would owe. There's no additional risk added by adding community solar. In fact, your risk goes down to $108.37.
I guess where I'm getting tripped up, Your Honor, is when you say that we're getting a benefit that maybe we shouldn't have gotten in the first place.
Because what's happening is the utility has been able to lower the bill for the customer. That customer's looking at two bills. All of a sudden, the utility bill went down by half. They're still looking at a subscriber bill that got lowered by like 10%, but that's still pretty high. They're feeling pretty good about the utility bill. They're going to pay that. That bill should have been twice as high if the customer hadn't gone with community solar. But they went with community solar, and then you've taken that credit value to lower their bill. That creates a lower risk for the utility by lowering the bill.
It creates a lower risk to our customer. Yes, that's why they signed up for community solar, so that they can get credits on their bill.
Yeah, but it depends on where the credit goes. I mean, you put the credit for yourself, yourself being the utility, and it lowered the amount of money that they have to pay for you. All I'm saying to you is by putting it back, by taking away that and giving it to the subscriber organization, you're not incurring an additional risk. All you're doing is putting yourself back to stasis.
And I'm sorry, I'm not trying to be dense, Commissioner. I'm just trying to understand. So if the subscriber credit, if that is going towards the subscription the SO fee first, there's going to be less that will go towards the utility charges.
It's going to be like it was before there was community solar.
Well,
nothing has changed. It's going to be the same.
Well, no, because, and that's what I'm not understanding.
Well, no, in the sense that you've been relying on this reduction in the bill. I mean, if there had been no community solar, there would be, I'm going back to
no
this.
reduction in the bill, Your Honor. I'm
That's,
sorry to
no,
interrupt.
if there had been no community solar, there'd be no reduction in the bill.
Correct.
Right. So all I'm saying to you is you're just going to go back to where you were before. You're going to have the same risk. Your risk was lowered. Now you're going to go back to where it was. It's going to be lowered a little bit more, but you're essentially going to go back to where you had been.
And that's where I don't think I would agree, Commissioner, because like I said, the risk is always going to be there. It's not going to be eliminated by going
but
with
risk
NC1.
is a relative term. You owe $20. That's a different risk than you owe $100. Your risk went down, and now it's going back to where it was. If we go under NC1,
Where it was would be the amount that was owed would be lowered by the full amount of the credit. That's where it was.
I'm talking about before there was community solar.
Before there was community solar, there was no reduction to the bill.
That's right. Right, and it could easily have been. You could instead of reducing the utilities charge, you could easily have just given it to the SO. You made a. I mean, there's this dual billing. I mean, I know we're sort of going around in circles, but and maybe we're talking past each other. It just seems to me that there is no change in risk if we go back to the way it was before you applied the credit value to the utility bill.
And I guess what I would say, Your Honor, is that we're not going back to what, under NC1, we would not be going back to what we would be doing in the absence of community solar. That is not what we are going
All
back
I'm saying to you is it doesn't change the risk, your initial risk. You were talking about an increase to I missed Miss Oho or
Miss Ono.
Oh no. Miss Ono, you talked about NC1 resulting in additional risk to ratepayers. And all I'm suggesting to you is that it's not changing the risk. You're just going back to what had been the risk all along, which is are you going to get paid by your ratepayer?
I think we need to think about where we're starting from, right? There is a status quo, I think back to an original discussion, and the status quo is dual billing where the SO has that risk, right?
No, status quo is before community solar.
So if we go back to before community solar, then there is no credit, right? But with community solar, now there is a credit. And just like net metering, the foundational principle of net metering is that compensation from net metering belongs to the customer. And so just like net metering, the credit for community solar, once there is a credit, really should belong to the subscriber to offset their electricity charges. That's how net metering works. So if there's no community solar, there is no subscriber, there is no credit.
I understand that. I'm simply talking about risk, and it just seems to me that the risk the risk has been borne by the subscriber organization, and because they're carrying the risk, the utilities had a reduced risk. As has ratepayers because of that. And all I'm suggesting is if we did an NC1, the utility would be back to where it was initially in terms of exposure.
But Your Honor, I'd like to talk a little bit about the credit, right? So once the subscriber gets a subscription for community solar, they're supposed to get this credit, right? It's supposed to be their compensation for having solar. So community solar allows a renter, for example, that's unable to purchase panels for their home to be able to participate and get the same benefits that they would that a net metering customer would get by installing panels on their roof. For net metering, when they put power back on the grid, they get credits that can offset their electricity charges for the month. That's the foundational principle of net metering, and that's the same thing that we're hoping to achieve with community solar. Give folks the ability to get the same benefit that a net metering customer would get. The subscriber really owns the credit. Now, the subscription charge is at the discretion of the subscriber organization. They can choose to charge a 50% charge, a 40% charge, a 10% charge, 90%. It's not fixed, it's not in law. They can choose to charge whatever they want, but that is their charge. And so when you talk about paying for that, I think what we're trying to argue in NC2 is that first, the credit belongs to the subscriber to offset their electricity charges. Next, you have the subscriber charge for them having this benefit. And we're saying that is not something that should determine if the customer gets terminated or not. Paying that is separate from the utility electricity charges.
No, I understand that. All I'm suggesting is that there is a risk that goes on the utility every time they bill a customer about how they're going to get paid, and the same thing is true for subscriber organizations when they go out to try to get customers, and deciding what piece gets paid first is part of what lowers the risk, and utilities have been paid first. And so it lowered their risk in a way that they didn't have. But I think we probably need to move on.
And just to mention quickly, today how it works under dual billing is that the credit is applied to the electricity charges. So it could include utility charges, it could include third-party supplier charges. So it covers the electricity charges that would help keep the customer's lights on longer, right? That's the whole point. We're not arguing for the utility, we're advocating on behalf of the customers. We're saying if they get the full value of the credit, they get to offset their electricity charges by a higher value, and we can keep their lights on longer.
Okay.
Yeah.
And I'm sorry, just to add on, and just one point I want to make is that under the status quo, under dual billing, it's not a matter that the utility gets paid first. Those are two separate bills. Whether or not a customer pays one bill or not, that has absolutely no effect on whether or not they pay another bill. So I don't think it's correct to say that we're getting paid first right now.
If it's lowering the customer bill by half, then you're getting paid first. Okay, that's all I have.
So, explain to me the job of your subject matter expert, because I have a question, but I'm not sure she can answer it.
The position?
Yeah, I mean, what her responsibilities
So
are.
no, yeah, she's a manager in our well, I guess what we call it, the smart.
I'm the manager for community solar at BGE.
Yeah, I mean her
so
job effectively.
my question is, under the current system, how big a problem is this? I mean, how many customers are in a situation where they're only paying part of the bill and creating this dilemma of who gets paid first? Do we have any knowledge
You
of
mean
that?
community solar customers or
Right,
just
yeah.
customers in general? I don't know.
Does
if
this
we-
happen
I don't know if
all
we've
the
had-
time, some of the time, none of the time?
We have it happen, but we don't have data available right now.
I see.
Yeah.
Okay, all right, thanks. All right, OPC.
Good afternoon, Chair and Commissioners. Brock Miller, representing the Office of People's Counsel. I'd like to thank those who spoke before me for their clear explanations of the consolidated billing options before the Commission. I participate in the net metering work group, and I'd echo Commissioner Suchman's comment regarding the complex and confusing nature of these options. Each option so far today was discussed, so far in the work group was discussed at varying levels of detail, but none were presented as clearly as they've been today, so that's very helpful. Since the comments were filed, OPC has continued to discuss and think about the various consolidated billing options both internally and with other work group participants, and as Mr. Coggeshall mentioned, our understanding of the various benefits and negatives of each one has continued to develop over time, and we see benefits to NC1 for sure. However, here, OPC's primary concern is reducing service termination for ratepayers. And as OPC understands the three options, NC2 goes the farthest to reduce terminations because utility charges, which if unpaid could lead to termination, are covered by the bill credit first before the subscription fee. To the extent that OPC's understanding is correct, OPC has a preference for NC2. And we, again, as I admitted, there's benefits to both, and we think that the Commission has a very tough policy call, deciding between NC1 and NC2. But in the interest of reducing service terminations, OPC recommends that the Commission at least consider directing the work group to use NC2 to draft the consolidated billing regulations. Thank you.
Okay, questions for OPC?
I'm exhausted.
This is how the work group goes.
No, I'm sure. Yeah, this is right. I really wish I were in your work group. No, not. So I completely understand I'm sort of. I'm not going to talk about the risk at all because I think we've sort of beat that one down. But I do understand the disconnection piece. I just don't think that the risk of disconnection has changed at all. All that's really happening is that you're finding another source of funding to prevent disconnection. So I think actually what would happen under NC2 is that you'd have overall for customers that are participating in community solar just reduced amounts of disconnection. So it's not necessarily going to increase or keep the same. It's going to reduce. But the concern that I have is by taking that pot of money to reduce the risk of disconnection, you're then going to, because you're increasing the risk to the subscriber organizations, it's just going to make it so much harder to do community solar. So I think it's sort of a short-term fix that would lead to a long-term problem for community solar.
I understand your comments, Commissioner. I mean, that's why that's a very tough call here, and we recognize that is a potential possibility with respect to the community solar.
Yeah, no, and I mean, you know where I am on the level of cost that low and moderate income customers are dealing with right now, and the risk of disconnection. So I sort of appreciate there is this sort of pot of money, but I just think that that pot of money needs to stay with the subscription organization fee to keep the process going, and maybe we'll just have to find another pot of money to try to prevent disconnections.
Completely understand.
Okay, thank you.
Sure.
Mr. Richard. No questions. Mr. Barvey.
Just a quick one. You do accept, though, that the very fact that customers are getting lower bills, that automatically lowers their probability of defaulting or underpaying, correct?
Correct, yes.
Thank you.
So you mentioned this concern about terminations, but under the NC2 method, where the subscriber organization is left to its own devices to collect money that they're owed, aren't you concerned about what practices they might undertake, and the fact that, given the fact that a utility can't terminate service unless they go through a whole set of rules and regulations that we adopted in regulations, but if they're using normal commercial collection practices, we don't regulate that.
That's correct, and that is a concern, admittedly, Chair Hoover. But between these two options, we just had to think about kind of what keeps the lights on for the ratepayers.
All right, and just to kind of, I guess, put you on the spot, but so your view is that 2 is better than 1, but it's not that 1 is wrong.
That is correct.
Okay.
Whenever we were first going through these regulations in the work group, our understanding was that we were moving forward with the NC1 proposal, and we were doing that for a very long time. And it wasn't until this NC2 popped up where we saw, oh, this does seem to be an option to somewhat reduce termination risk.
I see. Okay. All right. Thanks. So, Mr. Vanderhayden, for staff, go ahead.
Finally, at the last. I will be brief. I don't have a statement, but I'm going to try to make a suggestion here that I think might help. We talked a lot about risk, and I think, Commissioner Sussman, you're right about the risk to the utility not having been there before. So I think we have a situation where dual billing is on one end of the spectrum and NC1 is on the other. NC2 and POR are in the middle. And I think staff went with NC2 because typically we've seen the commission try to pick something that doesn't, win-lose or, lose-lose for somebody, win-win on the other side. I think there's a way we can incorporate some of the elements of NC1 where the customer, essentially sees the information on their bill. They know what they're buying. It's all in one bill. Of course, they all are all in one bill. But without the situation where there's absolutely no credit and collections and billing risk to this subscriber organization. So right now, with subscriber organization with dual billing, they bear all the risk of trying to collect their subscription charge. With NC1, they would have none, which leaves, there's still that risk of that money being collected, and we talked about that. So one of the ways that we could implement to sort of get that in the middle a little bit more and not make it zero on one side or the other is to use the transaction charge or that fee, which is nominally at 1% in the law, but allows for some additional increases when it's been demonstrated. And that's the reasons for I think, questions sort of, 4 and 5 on our list here. So, it's clear that the SO, or the subscriber organization, under NC1, they get paid, they read that meter and they get paid right away, and they get paid, less their 1% fee, which is in the law. They get paid almost 100% of what they get. They don't have, no losses. Customer doesn't pay, then they still get their payment. There's another problem that is a sort of a third level down problem is what if that subscriber goes and subscribes for more an energy than they actually need on an average basis or even each month? The subscriber is still going to get paid, and we talked about this, and so folks don't have to jump up and respond to this, but it's a problem that we will have to deal with either by doing something complicated with the billing, or we'll have to put some limit that says you can't buy more than your energy usage each month. And we've talked about that amongst the working group, and that is one of the issues. So NC1 is not without, as proposed, there's problems that we're going to have to deal with, and we may be back in front of you asking for a policy decision on that. So there's got to be something that makes sure this is all balanced. The other element of balance I want to mention is rooftop net metering. All of this is net metering. Community solar is net metering. In the law, and staff comments on page 2, we sort of laid out the arguments here, so I won't go over that. But that subscription is electricity by law, by definition in the law. And you can't use electricity to pay for things. You can use it to offset your own usage. And so this issue of, is the utility taking something that they weren't entitled to? Anybody who has rooftop solar is not paying the utility for whatever they generate that month. They put it back out in the grid. They bank the excess, and then they use it when they can. So all of those sales are lost to the utility, who recovers those sales through decoupling mechanisms. Community solar, although we've monetized it and turned it into dollars, should not be looked at any different than that. It is energy that is produced at a remote location on the distribution grid that is, by act of this law, treated by the utility as if it appears at your meter. So you get the exact same value. That's how we determine that value. If we were to have developed this policy back in 2016, thinking about it different than than rooftop solar, then arguments which were made at the time and dismissed by that commission, to my recollection, that, hey, it's not really worth the same amount because it has to get over here from wherever your facility is, and, by monetizing it, we have to worry about collecting it and that sort of thing. But at the time, it was dual billed. So the utility never had to take on those costs. I don't want to get back into that, but I'm just saying there's multiple levels of this. My suggestion is the direction you could give us, hopefully, in some real clear writing that you're going to give us very specific direction here, because I don't want to bother you with another one of these before we bring your regs. If there's a way to use the elements, sort of the positive elements NC1, pay the SO, upon reading that meter or on a regular basis, on a monthly basis, giving them not a zero credit and collections expense, but and I've always said POR actually does pretty much all of the issues. It solves most of them, if not all of them. It's just that we didn't want to get involved with POR because of the SB1 stuff, and it's been pointed out that that's not legally, a situation, but we just avoided that. However, using the transaction charge to allow the utility to recover any uncollected costs that are associated with billing these subscriptions, along with administrative charges, which I don't think anyone objects to, and programming charges, which I don't think anyone objects to. It's this element of, can we incorporate in that transaction charge something that recovers a portion of the credit and collections expense that is eliminated on the SO side, and that is now being picked up for right or wrong on the utility side, which they are going to recover from ratepayers. That, I think, is a potential path forward. And if we had guidance that said, look, incorporate it in your transaction charge, and then we'll address it, I think, at the time you file tariffs. And then that issue is, are we going to project it, or are we going to true it up? There's another issue which we have not talked about at all today that gets to the transaction charge, and it's because the law does something that says once you set it initially, you may not increase it for that particular project. And so that kind of creates a problem, because we have to project all of the forward expenses of the program. We don't know exactly how many participants are going to be involved, so it's really difficult to set a percentage number for the transaction fee, because you don't know what your sales volume is going to look like, going out to until that facility is decommissioned, which is plus 25 years. And it could create a scenario where that'll just have to get picked up by ratepayers, or it may require a review of how this is being done for the SOs. All of those things also create uncertainty for people who are trying to invest in these facilities and want to have a steady cash flow over the life of the project. So we've asked, and a staff's recommendation is that when we set these transaction fees, we recover the costs associated with credit collections, the programming, and administrative charges. We try our best to make a good estimate, which is probably going to be something that could get up towards 5% at the onset, and then lower it to the extent that it turns out not to be realized at that level, which then allows the flexibility to raise and lower it within that initial band. I think by setting it, now that number may seem high, although I don't think it's outside the bounds of what we have seen historically with credit collections expenses and the other administrative expenses that are in the retail choice market. So I'm sort of thinking of typical utility uncollected percentage of revenue as being in the low single digits, setting aside things like when there was moratoriums on terminations from the pandemic or something. So I think there's a path forward that gets everybody a piece and does not leave someone with sort of a lose-lose scenario. But we would need direction from the commission that says, we're gonna if we're gonna take this NC1 method, here's how you're going to, one, demonstrate your costs, and how you're going to recover those in a way that does not spread those out to ratepayers, but sort of in line with what the New York Commission said in their order, which is in this stack here, if you want me to quote it to you. It basically says, we're eliminating the credit and collections expense, we're eliminating the billing and collections expense for the subscriber organizations, and as appropriate for those costs to be socialized among the participants in the program. And so I think that's good public policy, that's cost causation, and I think it's in line with everything you've got in this law. So that's my suggestion, is how you might sort of solve this issue. Now I'm happy to field any questions you may have on that or anything else.
Commissioner Barbe.
Thank you, Mr. Chairman. You'd agree with me that the legislature really doesn't like purchase of receivables, right?
I would always agree with you, and yes, we are getting a real strong suggestion that that is a bad idea. Although, if you look
No,
at the
well,
implement-
no, that's not my question. They don't like it.
Yes, yes, they said they seem to give us a bill that we spent a lot of time working on it that don't do that for retail choice.
If they had the ability to drop kick it like a football, they would do that, wouldn't they? You don't have to answer that. Thank you, Mr. Chairman.
Commissioner Richard.
Yeah, thank you for your recommendations today. I just, again, trying to look at the letter and the intent of the legislation, I'm just concerned about a couple of your recommendations. I just wanted to understand better. You want to go to 5% as far as an administrative fee, but the legislature specifically has said that they wanted no more than 1% unless it can be justified.
Yes.
And they also want this to be very stable and a program that, that promotes renewable energy, particularly the community solar, and the involvement of LMI. So, going and setting something higher than what the legislature has asked for, and then also not kind of building into that making sure that it's going to provide that 10% return or that benefit to low income. I mean, how does your proposal accommodate that?
Well, for sure, we don't know exactly what the program costs are going to be. So you could take the 1% and say, hey, that's the most you can get as a fee. The rest of it we're going to collect from somebody, would be either basically all ratepayers or participants in the program of some kind. However, the fact that they acknowledge that it's 1% unless you prove otherwise, I think directs the commission and understands that, well, this is where we actually can consider costs and the level of detail needed to set these things.
Okay, well, I just, again, would caution that we not frustrate the intent of the legislation or what the legislature wants us to do here. Just in the whole policy of net metering, I know you've done studies and other that, yes, if you were just to look at it on economic terms, it is something that would have questionable, unfair impacts on ratepayers. But it is a policy of the state to try to promote renewable energy, get citizens involved, and then we took the next step of having community solar so that, again, we can make that available to all of our citizens, whether or not they have a home that can, or they can afford a solar panel. So, again, looking at what we're trying to do today, I mean, how are your recommendations accommodating that? How are we going to support that state policy?
So we need a program that is sound and sustainable and easy to implement. And I think, as you can see from the massive discussion we have today, there's all these moving parts. We need to come up with a way to make it clear to outside investors, okay, this is what you're going to earn over time. We have to make it, we don't want to have a situation where you have a cost that starts to spiral out of control that does not have a way to be recovered, in a manner that's consistent with how the program is set up. So I guess what I'm trying to say is,
we're trying to spiral out of control. I mean, but we have probably one of the largest groups of investors, of companies that do community solar here, and I think they've given us some input that, if for them to do business in Maryland, for them to participate in this next phase of the program, they're going to need, to be accommodated as far as having the ability to, serve the customer, but also get the return they need to be able to get the capital. So again, I mean, what weight do you put on the fact that we have all these companies that would like to do business here, and they're giving us basically what has worked elsewhere, New York, and what they need to succeed in Maryland? How do we factor that into?
I think, and I can't fact check, what was said by folks here. I'm sure they are, advocating their best for their organizations. I think you look at the volume of projects that are coming in. I mean, there are, I think we put it in the net metering report, there are, hundreds of megawatts in our authorization and in the project queue at this point. They, they're doing that without specific knowledge of how this particular proceeding is going to go. That seems to indicate that the availability of capital to fund these projects is not being affected by something that, we're talking about may or may not, affect 2 or 3% of revenue. And I don't, I've not heard, and I try to talk to, folks in the industry. People call me all the time and want to learn about the program. I try to speak with those people. Had the opportunity to do that at the solar conference last week. And, I think certainty when it comes to investing is really important, like knowing, how much this is going to return, what are my expenses going to be. So I think we can't ignore the fact that there are sort of other costs that are part of this program. In terms of the administration and the program, we haven't really gotten into that, but I think those will be important costs to the utility that has to implement it. But at the same time, community solar and distributed generation, that's just one of the many policies that the commission's directed to implement from the legislature. We still have the basic underlying cost causation and regulatory principles. So I think we're trying to sort of fit everything together. But I mean, ultimately, you want something that is well understood and provides the certainty so you can attract that capital. I think I'm just trying to get to your question.
Okay, thank you, Mr. Thank you.
Okay, so I think we're all tired. So I'm going to try to make this brief. I'm sort of loath to send the group back with directions to try to do something other than, go with a program, because it just seems like you'll be back, and then we'll be cranky. And I'm sure you guys will be cranky too. So I'm not really understanding what I mean. It sounds like you guys came here because you were at an impasse. So sending you back doesn't seem to make a whole lot of sense to me. And then trying to sort of parse through what's a good approach between NC1 and maybe not. I'm trying to understand. I mean, do you really feel like us sending you back with some sort of guidance, but then trying to find a path forward is going to make a whole lot of sense? I mean, it doesn't seem that way to me.
So just sort of reading the room a little bit, it sounds like NC1 is sort of carrying a lot of weight right now. So if you maybe say, hey, we like NC1 as proposed, we're going to essentially eliminate the billing and collections, costs associated, with providing the subscription under, that the SO has. We'll just implement that. I mean, I think Mr. Bugelmans has a set of regs ready to roll with, he's nodding his head, ready to roll with that set. I think there'll be some complications, but once we know that, hey, this is what we're going to deal with, now we'll address the complications. That will still get complicated, but that's what we'll do.
Okay.
I think we just need something that says, here's what we want you to do. Now, if you're listening to the information the utility said and you want to parse that differently, we may have to ask a couple of questions or something, but I think you've got
That's fine. All I'm saying to you is I don't know that we can really sort of come up with an alternative. I mean, I think we have what's here, and I think we just have to give you direction based on that.
Sure. Yeah.
Okay. Thank you.
So let me ask a process question. When the community solar folks were up here, they were talking about the fact that, in their view, time is of the essence. So given the fact that we're not going to make a ruling today, how much time do we have to make a decision on this?
I would say that it is something that our working group process actually, while we set this aside, we're engaged in some other things. We would need to have something back by the commission first of the year in order to begin using that to start drafting. Drafting, once there's direction, drafting the regs isn't as hard, and so I think we need the time. We have, we're dedicating ourselves meeting almost weekly or biweekly just to get this out the door on time. I mean, I'd maybe see if anybody else is violently disagreeing with the first of the year. I don't see it, but based on what usually happens in December and other things, I think that would be good for us, unless anybody objects.
Okay, so let me turn back to Mr. Bugelmans, but I guess what I want to do is I would rather have him speak for the entire industry. So if you need to consult any of your allies before you come up there, go ahead. And if you need a break, I can accommodate that.
Thank you, Chair Hoover. With respect to timing, I think what we've learned actually from the first phase of rulemakings to implement the permanent program is time goes by very quickly. So I think January 1st to 2025 is frankly way too late. I understand the commission has a lot going on. We are in the holiday season, but the earlier the better for a decision. I will also say in terms of implementation, we do have regulations that we were working on with the work group that accomplishes NC1. We were even working through some of the fine details. So if we got an indication that we're going with NC1, we could really sort of get to the the meat and potatoes of figuring out the details to get this to you, so we could have a rulemaking hearing and then get it kind of in process. So it's published in the Maryland Register on time. I guess a few other points. The point that Mr. Vanderheyden had about there's a lot of projects sort of applying for SO approval, trying to get in the process. That is true. There's a lot of interest in this program. But I can tell you from experience, there is a significant amount of anxiety from developers that aren't even necessarily CCSA members. They know that there's a possibility the commission could choose NC2. It is really concerning them in terms of their ability to move forward with development. Projects aren't financed yet. Initially, they're when you're kind of getting a project going, there is some money there to pay for processing fees and consultants and lawyers to do permitting. But until these things are actually financed at construction, they're not real. So even though there's interest now, this really is an important decision for purposes of the program. One other final point with respect to the administrative fee. The legislation's clear that the utilities can implement a 1% administrative fee. It's called an administrative fee, not a transaction fee. Anything above that, the commission needs to set basically based off substantial evidence presented by the electric company. So when I see substantial evidence presented by the electric company, the commission has to determine that the fee is just and reasonable. So when I see those terms in a statute, that suggests to me at least it's something akin to an evidentiary process in the context of a rate case based off of actual costs. So I think for purposes of the decision here today, I think there's a couple things here. I guess the main point is that the commission doesn't need to reach a decision on what that would look like, except that it would be through a later process based off substantial evidence. So I would urge the commission to not get hung up on that piece of the decision. I think that'll be sorted out at a later stage. I will say that the idea of using highest cost estimates, I think I've heard staff raise that. I mean, that is, if we're talking about cost of service regulation in the context of a rate case, that's basically the opposite of what you would be trying to do. So we have concerns about that, but I don't think we need to figure that out today necessarily. It's really just, are we doing NC1 or NC2 or POR?
Okay, so I'll make a commitment that we'll get something out earlier than December 31st. I won't necessarily commit today as to what it'll be, but I understand your concerns about getting the process rolling. So with that, I think we're adjourned for today.